Any mention? Item number 1.
May I please, Lordship?
Yes, Mr. Kumar.
My lord, I have the instruction to appear this matter, my lord, so I will file my Vakalatnama today itself.
How many respondents are there?
Only one respondent.
Only one. Mr. V. Kumar has entered appearance on behalf of the sole respondent today. Such service is complete. List the matter for admission hearing. Is there any delay?
There is delay for 89 days, my lord. But,
How many days?
89 days.
89 days.
You have any objection to coronation?
No, no, my lord.
Yes, then okay. So right. Miss Case 21, 2024. Stop. This even the earlier case in the miss case. Huh? So no, in the instant miss case, brief condemnation of delay of 9 days and preferring the appeal against judgment order dated 15/3/2020 file. The reasons, the reasons for delay are set out in paras
3 and 4.
3 and 4. There. Stop. Next part, Mr. V. Kumar, Leonard, counsel for the opposite party. The respondent has no objection if the condemnation is delayed. Accordingly, for the reasons as set out in the paras 3 and 4 the application, and no objection being raised by the respondent, let the writ appeal be registered and diarized. Yes, only sorry. The delay is condoned. Registry to register and diarize the writ appeal. So, list on after 2 weeks.
My lord, deeply your lordship.
Hearing item number 2.
What about that? Yes.
My lord, this matter relates to that removal or termination of the assistant professor in a women college. Now, my mainly 2 grounds I have taken, 2 findings arrived by the single bench. Number 1 is, my lord, the computer department is no longer in existence in the college.
It's for hearing today.
Hearing today.
Okay.
And
You
number
all
two-
ready? All are represented?
Admission hearing, Your Lordship, which Your Lordship was pleased to hear on the last
We'll
occasion.
dispose it of also. What is there? I think the Charesu is ready with the matter.
Lordship,
Yes.
Second is, my lord, the writ petition against the women college is not maintainable. My lord, relying on the St. Mary's judgment pronounced by the Supreme Court. Now, my first contention, my lord, there are 2 types of departments in all the colleges in the state. One is, my lord, affiliated departments under the NEHU, the degree
What 2
courses.
affiliated departments
And, my lord, non-affiliated departments. And non-affiliated departments are such that it imparts short-term courses, certificate courses by the colleges.
Yes.
Not only this women college, but other colleges also, they do that one. Admittedly, my lord, he was appointed for class 11 and 12. And class 11 and 12, my lord, computer department is there, under the imposed syllabus. Imposed. They did not deny this. I was inducted for this. I do admit that there was no interview, because, my lord, except the grant and its sanction post, none in grant sanction post, we can say the college sanction post, appointment is vested with the management, However, under the Act, my lord, when they are sought to remove the college sanction post teacher, or we can say a higher secondary school teacher, then they have to take the approval of the government. And with regard to, my lord, any college teachers who are appointed for a non-sanctioned post, and they try to remove from the service, the principle of natural justice is required. But I'll place those rules and act also. Now, admittedly, I was inducted for class 11 and 12. And I was given the additional assignment to teach in the degree level. So my primary assignment is class 11 and 12. In that point of time, my lord, there was no bifurcation. class 11 and 12 are together with the degree courses under the same management. And
Which year you said you were appointed?
my lord, 2013.
2013.
13. I was regularized from that time. I'll show my lord.
Regularized, but if you remember correctly, is on the basis of just there's no formal appointment order. Correct?
My lord. My duty, therefore, is to persuade my lord that how the conduct of the management would demonstrate that the person's service is given the permanent status or not. I'll place one judgment, my lord. Normally, my lord,
What was the opinion of the learned single judge on that aspect?
my lord, there is no finding.
There's no
There's
finding.
no specific finding, but though he has recorded the contention of both the sides.
Okay.
Both the sides, my lord.
Let's continue.
Both the sides. Single pen did not say that there was no appointment. Therefore, petition is suffer from that. He didn't say, my lord. Now, normally, lordship is aware, when a person is appointed, then appointment order will be issued and regularization confirmation whatsoever and continue, my lord. Now, the question arises, when the management appoints somebody and do not give an appointment letter, and that particular person is allowed to teach or to work in the office for a long period of time, the apex court held that the conduct of the employee is very, very vital to determine the status of that particular employees. Because none of the employees would be willing to go on without certainty of his future. And at that point of time, 2010, 11, 12, unlike today, few youths were well trained, equipped with a computer education. And this fellow is one of the exception. So had he aware that his service is a case lecturer, attracting only 250 per lecture or 500 rupees, he would never continue. He was inducted along with others. In others, they have given appointment, no selection process. As I said from the beginning, since it's a college sanction, college post, appointment was done by the governing body only, and to some they have given appointment. These particulars and others, they did not, therefore, even college, the Teachers Association raised this point, urged the managing body that you please kindly issue appointment letter to those teachers. They did not issue. And because of that, some of them withdrew, they walk away from the college. Some continue, and some got the appointment.
Then what happened?
Now the conduct, my lord, I would show that the conduct of the college itself says that.
So you see, one thing, Mr. Changre, so is that you have to first show how the single judge's order
My,
is,
my, may I just show the refer
where
to
the infirmities,
yes, my,
in the judgment
yes,
that you've come up. You remember that a writ appeal is a continuation of writ proceedings,
yes.
and so you have to show us why you feel that the intervention is required by the division bench in the order of a single judge.
But may I start from para 9 of the short
Yes.
judgment delivered by the.
Yes, where's that, Mr.
My lord,
Changre, sir?
I may come to para 9.
You place the judgment of single judge? And
My lord, single judge, my lord, may I come to page number 370,
370.
my lord.
7370.
370.
Okay.
370. And I may start from page number 377.
Yes. Yes.
Lordship permits me.
Can you read this?
Yes, madam. The petitioner was employed in the college and necessary permission was given to the college only to run higher secondary classes, which is not disputed by the petitioner. The petitioner was paid monthly wages initially and was thereafter brought under scale of pay, and also the revised scale of pay was remunerated to him. Thus, it is apparent that the employer, namely the college, does not want to discriminate teachers in respect of payment of salary. May just pause for some time here. None of the ad hoc appointees are enjoying regular pay scale. If Lordship summon the records of the college, it will reveal not only me, but others. But those who have a sanctioned teacher, college sanctioned teacher, they enjoy the regular pay scale. Even assuming for the sake of argument that he was allowed to continue in the college against the sanctioned post teacher to impart education on computer application, it can be implied that it was only for the higher secondary section and not otherwise. Not otherwise. Once the sanction has not been accorded by the university on account of bifurcation of the college from the purview of the secondary education by its communication that it's such and such, this communication was never brought on record. Till date, he is not aware. The request of petitioner that he should be continuing in the college to conduct classes for the students cannot be accepted and is next to impossible. Though the college has offered him the post to class 11 and 12 students on a lower pay scale applicable to the state post, petitioner has turned down the state offer and refused to join the lower post. Now, if I understand this properly, my lord, here learned single bench failed to appreciate the two facts, that the one post for class 11 and 12 is there, still in existence, and I was inducted for that. My lord, if the contention of the college accepted that my assignment to a degree level is the additional assignment, since originally I was appointed for class 11 and 12. In that case, my lord, my case is deserved to consider for class 11 and 12 properly, my lord. Only, my lord, this single bench went ahead and said that because of the bifurcation, department is vanished. It seems department is vanished for pot. So that is incorrect. I would demonstrate, my lord, that department for class 11 and 12 still in existence under the MPOS. Full-fledged syllabus are going on. And the computer education for the degree level skill-based course is still continuing.
It's still existing.
Still in existence. Still in
Okay.
existence. Still in existence.
Yes.
But therefore, informity, the judgment of the Apex Court reported in the St. Mary's Education Society held the petition is not maintainable against the private party having public element, and the relevant paragraph such matter. From the pleading and original petition, it is apparent that no element of any public law is agitated or otherwise made up. In other words, the action challenge has no public element, and writ of mandamus cannot be issued as the action was essentially of a private character. From the above, it is very clear that the petitioner is not entitled to any relief, and even assuming for the sake of argument that writ petition is maintainable, when the post itself is abolished on account of bifurcation. It is absolutely incorrect, with due respect, madam. Petitioner cannot seek a direction from this court to continue him in the said post, which is no longer in existence. If the submission of the petition is accepted, it would amount to creation of a post and issuance of appointment to teachers by the court, sitting on the administrative side, which is not permissible. Learning Council for Petition has relied upon the decision of the Apex Court and such, sustaining his case that since the college has been receiving aid from the college, but I did not argue that college, my lord, for this particular teacher is receiving, but other sanction posts they receive. The writ petition is maintainable. Of course, he fairly concedes that there was no aid granted to the post, which the petitioner is holding. The decision referred by the Learning Council for the petitioner was considered by the Apex Court, and the subsequent judgment referred to in supra, in such matter. Para number such categorically held as follows, madam. So this is, madam, and may come to para 12. That apart, even a glance at the communication dated such of the faculty members, women college, such addressed the President, governing body, condemning the discontinuation of service of the petitioner, which was produced by the petitioner himself. It is vividly apparent that he was conducting computer classes for 11 and 12. Though it was argued on the side of the petitioner that he was assigned to conduct regular environmental science classes at degree level, there is no evidence adduced to that effect. But no, in the annexures earlier also I have shown, madam, the number
So
of
your grievance is limited me to para 9 onwards with the finding
madam.
that he was teaching only 11 and 12.
Yes, 11 and 12. In fact, I was, it is true, 11 and 12 I teach, plus degree level, short-term courses. Class 11 and 12 is a full courses. Degree level is a short-term 6 months skill courses. So the finding written by the only single bench is incorrect, my lord. Incorrect. And the evidence, my lord, I annex in the writ petition and the affidavit, it is very clear that the Department of Computer Education is in existence. Because of that, even college secured the grade B in national accreditation. Their own paper is there. Full syllabus course are there, I will show. Looking at any angle, in my considered view, the writ petition is not maintainable when the post itself ceases to exist, owing to bifurcation, and the college has no sanction post to accommodate the petitioner. Hence, this court has no other option but to dismiss the petition as not maintainable. So my humble submission, my lord, is a short order that learning single bench committed an error, that the post is no longer in existence. Perhaps, my lord, in the mind of the learning single bench, my lord, the
But
degree
see, you're looking at from the other angle,
Right.
the post never existed because you never taught or were accommodated or even ad hoc or otherwise against a sanctioned post in the college. You were just like a free agent in the whole system. like, okay, they use your services, no doubt, but then it's not a case of you being appointed against any, or you being allowed to serve against a sanctioned existing post. So the post was never existing, that means, as what, I think that's what they will say. Never existed at any point of time.
Now, if the post was never existed from 2013, the question of granting regular pay scale do not arise. Well, therefore,
that is how they manage that, we don't know. But the fact remains that, see, your rights will be, will be, what do you call it, strong if, suppose you were allowed to serve against the sanctioned post and later on you were kicked out. That's the thing.
Now,
yes, continue. Yes, literally that, because regarding you saying that the post non-existent was existing. Now that, how can we go into that now? You know, whether the post exists or not. And from the materials, it shows that there was never such any post.
Well, yes. The materials were annexed in the petition here.
Yes.
My Lord, if I show up, my Lord invites the Lordship attention to the annexures to persuade my Lord that the posts are in, the department is in existence and the post is in existence, my Lord. My Lord, may I just take a few annexures? I'll not read the annexures,
yes,
but
yes,
show the
course.
particulars. My Lord. Now, after, my Lord, I was, my Lord, page number 67, my Lord. The governing body has, my Lord, brought me under the regular pay scale, my Lord. Page number 67, my Lord. At the bottom, my Lord, Mr. Ajit Paul, Department of Computer Application, my Lord. At the bottom, my Lord, Mr. Ajit Paul, Department of Computer Application, to be brought against the college pay scale. It was never given to any ad hoc case lecturer. It is only given to a sanctioned post teacher. If there is no sanctioned post teacher, my Lord, GP would never adopt this resolution and brought him under the college pay scale. This is one piece of evidence. Now, another one, my Lord, I'll come. Page number 71. That governing body resolution was adopted on 10 June 2013. Now, page number 71, the college principal himself, while issuing salary certificates, he himself says, my Lord, certified that Mr. Ajit Paul is serving this college as a full-time lecturer in the Department of Computer Science since such and such. That was my initial appointment, my Lord. Currently drawing salary of college pay scale rupees such and such. Ad hoc teacher case lecturer never draw this salary. And this salary is only for the full-fledged college sanctioned teacher. He himself, head of the college, said, it is not my document. This is one piece of evidence to show that he has been granted the sanction post. And another, my page number 72, allow him to contribute contributory provident fund. No case lecturer, my Lord, no ad hoc teachers are ever allowed to contribute this, participate in this. Only, my Lord, the college sanction posts and aided teachers or lecturers.
So your argument is that is upon the trappings of a regular post. I mean, in every man is treated regular employee in all respects.
Well,
okay.
Because they are not only me, other, my Lord, number of college sanction post teachers, lecturers are there, even till today, in the same college, who are not receiving grant in it, but enjoying the college sanction post pay scale. They are not ad hoc teacher. Another piece of evidence, my Lord, I'll show. that page number 139 onwards. Last time, my lord, page 139, 139. When the college is, my lord, put an effort to upgrade its datas, my lord, they used to furnish the departments and the sanction strength to the center, the ministry, my lord. I have shown last time, my lord. I'll just show only one. 2013-12. I'll show, my lord, to you. Page number 142. 142, my lord. Detailed program offered by the college. These are faculty departments, my lord. Out of 11, number 4, computer application, my lord. The remainings are, my lord, the degree affiliated to the university. And this number 4, computer application, it is not affiliated to university, but it is run by the college itself to impart short-term certificate courses. Now they furnish this to the ministry from 2013-14 onwards. And how can they say that there is no department? Well, I'll come. Now the sanction 1, the lecturer, my lord, page 145, page number 145, my lord. Now the lecturer, well, computer application by designation, post of the designation is lecturer, and category general, my lord, total sanction post is 1. My lord. Then similarly, I'll go.
What are you reading? 145.
145, my lord. Yeah. In the middle, my faculty.
Okay.
Department, computer application.
Okay.
Now, when they show the general category, my lord, designation lecturer, and the number of posts is 1. My lord. This is 1, my lord. I occupy that position, my lord, that position. And I will skip further to other years and come to closer years, my lord. And my lord, be kind enough to come to page number 178. Submitted to the ministry for the year 2015-16. And page number 181. And serial number then, computer application. Department still exists in 2015-16. I was teaching that one. And continued, my lord. Continued. Sanction, my lord, number of sanction posts is still available 187 and 88, 188. Sanction post is 1. One teacher, one lecturer. My lord. They did not mention the name of the lecturers, other department also. They mentioned the sanction strength. And they admitted that 1 post is there. But if there is no post, my lord, no sanction post of the college, my lord.
What is sanction post of the college, Mr. Sangresho?
My lord,
If you say college sanction post, what does it mean?
my lord, if I understand properly,
Which way you distinguish a non-sanction post of the college and sanction
my
post?
lord, my lord, 3 persons are appointed as lecturers. One, Mr. A is enjoying grant in it from the government. Then this is called grant in it sanction
You
post.
see, we know that is
My
sanction
lord.
post.
Second is, my lord, second
Sanctioned by the
category is,
government.
yes, second category is, he is appointed as a lecturer. He is not enjoying any grant from the government, but he is paying regular salary from the fund of the college. It is called a sanction
College post.
College sanction post.
So the state has no connection.
Yes, state.
It's
And
totally-
another one.
Totally private.
Yes.
Totally private, by the college, under
Yes,
the college.
with regard to his salary benefits, it is borne by the college fund itself. And third is the ad hoc matter. And I'll come to another piece of evidence to show that, my lord, page number 198. Department of Computer Science and Application. This is for the degree level. My lord, certificate course in office automation. Objective, my lord, eligibility plus class 10 and 12 examination. 1 hour, my lord, batch 20 per batch. Sorry. In order to be eligible for certificates, my lord, this is a detailed, my lord, syllabus for the short-term courses imparted in the college where petitioner was engaging throughout.
This is office automation.
Yes. My lord, therefore, as I say,
Windows and
yes,
Excel.
my lord, had the NIHU approved the department, NIHU would approve for the PCA, Bachelor of Computer Application. And since NIHU did not approve, they are offering the short-term courses. And for that short-term courses, they appointed.
Okay.
My lord. And my lord may come to pay another evidence, page number, my lord, 211 onwards. Well, the faculty members of all departments present their talk throughout the academic year on topics mentioned below. In the middle matter, computer applications, secure e-banking, Mr. Ajit Paul. These are all the evidences of the colleges. And none of the other departments show the case lecturer, name of the case lecturer, visiting lecturer. Now, another material may I show, Lordship, that page number 217. A variety of short-term courses they offer, my lord. And the 4th July 2019, Mr. Ajit Paul is a principal. As per the proposal submitted by the Social Work Department of Women's College, it is hereby decided the computer classes for social works, 5 semester students, my lord, semesters, 2019 will be conducted from the current academic session, such. Mr. Ajit Paul has to take charge of the classes. Student has to clear the fee of 1,000 before they enroll for the course. This is one of the course, short-term courses, and I'm in charge.
Yes.
My lord. And the same page 218, prospectus of 2022, when I was removed already, I'll show, my lord, how department is still in function, available. This is the prospectus of the college. Now I will come to, my lord, well, page number 224, Lordship permits me. They reflect the NASC Council, Accreditation Council. Then I'll come to the main skill development initiatives. Now may I come to page 228, Lordship. Madam, it says that the degree program, the college is, my lord, affiliated to NEHU for conducting its degree program in the art stream. Students admitted to the program would, as per the prevailing system, have to appear for end semester examination conducted by the NEHU. Professional program, the institute offers the bachelor degree program in social work, such. These are the, my lord, the other academic.
What do you want to show by this one?
Now, my lord, I'll come to the next page, 229.
Yes.
229. My lord. Under NEB 2020 focuses on skill development programs wherein it supports beginners by bringing innovative skills and technologies to the community for better quality of lifestyle and livelihood, and which is in the long run would create sustainable and visible social impact. This program emphasizes on stimulating a scientific outlook among members of the community and develop scientific attitude, curiosity, and capability to experiment and adopt new skills and innovation to improve their lifestyle and their livelihood. This would be, in the passage of time, contribute towards the upliftment of the society as a whole. Abiding by the objective of the NEP 2020, Women's College Shillong has also introduced a wide array of certificate courses besides the standard academic program prescribed by the university. Students of the institutions are expected to make choices of at least one such course in a year.
What relevance is this, Mr.
My lord,
Johnson?
the computer department is, my lord, code your web design. This is one of the skill course they are offering. They just simply change from a computer department to web, my lord. Go to a website.
Certificate courses, I think there's more diploma. I think. Go for law.
And page number 231, my lord. If Lordship can see the fee structure.
Yes.
Page number
231.
231.
Yes, basic accounting code,
Yes,
your
my lord.
website.
Yes, my lord. Go to your website, 1,900.
So that's what, these are all certificate courses which you pay. It's besides the basic academic curriculum that's taught.
Yes, yes,
Yes.
yes.
So
And
you
I
have
was-
a role in conducting all these.
Yes,
That
yes.
is your
Right,
submission.
right, right. Hundreds of students are there.
Yes.
Then they engage in
Right.
this.
But this is, you
skill-
said this is the prospectus for 2022 and it's already out from the college, right?
My lord, I was out in
If he was
2020.
there, he would have conducted these classes.
I would be conducting these classes, my lord. Classes. And now, my lord, may I come to one syllabus offered by the impose. That is page number, my lord, we come to 301.
301.
My lord. A true RTI they provided. My lord, in response to your application on the above mentioned subject on receipt of the payment of the prescribed print course charge such on being course of providing information, I am therefore furnishing here with copies of the syllabus pertaining to computer science for higher secondary, arts, science, commerce, imparting by the school affiliated under the impose with effect from such 2010, such. Now detailed syllabus, my lord, the next page. Detailed syllabus are there. So assuming that my assignment for degree level is a temporary in nature, my lord, and my appointment is you enter in the service under the for class 11 and 12, I need to retain under class 11 for class 11 and 12 to continue this, and this syllabus I continue to teach. Therefore, with due respect, learned single bench returning a finding that there is no post at all, amounts to ignoring my status as a lecturer, also to a teacher for class 11 and 12. Also. And this course is still available. Still
Okay.
available.
Next.
And the
Yes.
appointment given by the college that they offer me for this post, class 11 and 12, there was no such incident. If they offer me, definitely he would have considered. But there is also the evidence is not there in the pleading also that they offer me, my lord. So this, my lord, these
What's the
materials.
petitioner doing presently? What's he doing presently? He's
My
not
lord, he's-
gainfully employed.
My lord, he used to take tuitions to some of the students, and even last year also, the impose engaging for framing the question papers for class 11 and 12 for the entire board. But he's academically, he's an excellent person.
Very
in
sound.
fact. My lord, with regard to bifurcation, where learned single bench return a finding,
Yes, yes.
page number 334. My lord, if Lordship kindly see. Madam, 334, Mary. In accordance with the Section 3 of the NEHU Act and meeting in line with the national pattern of education on the decision of the EC and Academic Council of the University and with the concurrence of the Government of Meghalaya and Mizoram, the Vice Chancellor is pleased to transfer the pre-university level education currently affiliated NEHU to the respective State Board of Secondary Education Government with effect from the commencement of 1995 academic session. And the name of the college is next page, serial number 16 is the Women College.
Yes.
So if that is the case, bifurcation took place in 1995. So the plea taken by the respondent that bifurcation took place in 2019 is incorrect. And that was a belief by the learned single bench. And the letter dated 1/4/2019, my lord, it is not part of the counter affidavit. Till that we are not. And learned single bench appreciate that on that basis, he rendered the judgment that there is a bifurcation. In view of the bifurcation, you don't have any rights. Even if bifurcation took place in 2019, my lord, class 11, 12, my original appointment remained the same. They would have said that no, class 11 degree level, there is no full-fledged NEHU affiliated department, and we can't afford to continue. So your service will be confined with the class 11, 12. And the pay scale is this one. That is one way. But completely done away with and say there is no more department is absolutely incorrect. So my lord, my humble submission with regard to this is the materials I have adduced, my lord, I believe that would persuade my lord that department, short-term course department, computer department still was in existence throughout, and even it is continued, my lord. Therefore, learned single bench returning finding to that regard is, my lord, incorrect. Secondly, my lord, second aspect of the matter is that, my lord, that writ petition is not maintainable.
Yes.
My lord, I will rely on some authorities to persuade my lord that how it is distinguishable. Now, with regard to my lord, as I said, for appointment, it is a discretionary power of the management to appoint a person for those ad hoc or college sanctioned college teachers. But when it regards to my lord removing terminations of class 11 and 12 teachers, it requires prior approval from the government, competent authority of the government. I'll place that one. And second part, my lord, removing any lecturers from college level who do not enjoy grant in it. It clearly spell out, 2013 rule clearly spell out that principle of natural justice is required to be adhered to.
What authorities are relying upon?
My lord, no, so learned single bench rely on the...
You have given the citation the other side?
The list of books. My lord, these are books, my lord.
You furnished some books, right? Yes.
My lord. May I just go 2016 volume 6 first, my lord.
You have not furnished us a list of books, Mr. Sanresha.
Yes, we have furnished already to the court master. Madam, 2016 volume 6 SCC
Rajkumar.
541, my lord.
Yes.
Yeah, I'll come to page number, my lord, para 40 and 57, my lord. My lord, here also the school, my lord, the affiliated, my lord, recognized under the
Para?
Nehru Institution, para 40 and 57, my lord.
40 and 57.
Recognized school. I'll come to that St. Mary's Education Act later. My lord, para 40, my answer to point number 3. The Learned Counsel for the appellant contends that the respondent school is a recognized private school, and the appellant is an employee in the terms of Section such of the Delhi School Education Act. Chapter such provides for terms and conditions of services of an employee of a recognized private school. Section such Act contemplates that no employee of a recognized private school shall be dismissed, removed, or reduced in rank, nor shall their services be otherwise terminated except with the prior approval of the Directorate of Education Delhi. In the instant case, the respondent managing committee, before terminating the service of the appellant, did not comply with the said mandatory provision of such and such. The Learned Counsel for the appellant further contends that the notice regarding termination of service was served on such and such, and as on that date, the aforesaid statutory provision was valid and binding. The Learned Counsel for the appellant submits that such and such is a substantive right provided for safeguarding the condition of services of employee. My lord. May I come to another page, page 57, to save lordship time. Well, page number 57. For the reasons stated supra, we are of the view that the impugned judgment and order 2008 passed by the Delhi High Court is liable to be set aside and accordingly set aside by allowing this appeal. The retrenchment of the employee appellant from his service is bad in law. The respondent managing committee is directed to reinstate the appellant at his post. Consequently, the relief of back wages till the date of this order is awarded to the appellant, along with all consequential benefits from the date of termination of his services. The back wages shall be computed on the basis of periodical revision of wages salary. We further make it clear that the entire amount due to the appellant must be spread over the period between the period of retrenchment and the date of his cessation, which amounts to 13 years, for reason that the appellant is entitled to the benefit under such and such and such. Well, this is also once a school is a recognized private school. Appointment here also, my lord, appointment is with the management. But when it comes to termination, removal, it requires approval. Another judgment, my lord, 2000, my lord, 2011, volume 13, my lord.
2011?
Volume 13, SCC page number 760. Relevant para would be, my lord, para 25.
25.
My lord. Here also involves a recognized unaided school.
25.
My lord, para 25.
Yes, 25.
My lord. May read, my lord. Pardon me. Where a statutory provision casts a duty on a private unaided school to pay the same salary and allowances to its teacher as being paid to teachers of government-aided school, then the writ of mandamus to the school could be issued to enforce such statutory duty. But in the present case, there are no such provision requiring a private unaided school to pay to its teacher the same salary and allowances as were payable to teachers of the government school, and therefore mandamus cannot be issued to pay to the teachers of private recognized unaided school and the same salary and allowances as were payable to teachers of government institutions. Now, what I'm trying to bring home, my lord, when statutory provision casts upon a duty, this with regard to the payment of salary. In my case, when statutory casts a duty on the authority to obtain permission from approval from the department before termination, my lord, is one of the mandatory statutory duty cast upon the department. I'll come to that act, my lord. This one, my lord. And another decision, my lord, may refer to, my lord, my lord, is a downloaded copy.
It is
This is, my lord, 2015. My lord.
it's not reported in the.
My lord, I
not reported.
will, my lord. It is 2015 reported, my lord. I will provide the reported.
You prepared the citation. Yes.
My proper citation. For the time being, my lord, may just this judgment also referred by the Supreme Court. My lord, please, may I just read a few paragraphs regarding this and may proceed. Para 6, my lord. Para 6.
Sealing the order of termination.
Assailing the order of termination, Respondent number 1 filed a writ application before the High Court. Learned single judge of the High Court, White and Sir, dismissed the writ petition on the ground that as the concerned school was not a recognized primary school by state government but a privately managed primary school, writ application was not maintainable. However, it allowed Respondent number 2 to institute an appropriate suit for seeking relief claim in the writ petition. May I come to relevant para 12 onwards. Para 12. Firstly, we examine the question with respect to the maintainability of the writ petition. Writ application. It has been clearly averred in the writ application that the appointment was at first on probation for 2 years. It is not in dispute that in the instant case, the approval of the appointment had been made with the retrospective effect from sunset, and no approval immediate was obtained for the purpose of removal passed on sunset. There is a clear pleading in the writ application that approval was necessary. Its denial in reply is evasive. No such approval had been obtained in the instant case. It is apparent that the government also pleaded in its reply that approval appointment was made necessary, considering the arbitrariness in the appointment which was prevailing. And once approval for appointment necessary, there is no doubt that approval for removal also necessary.
Was this placed before the single judge?
My lord.
Was the judgment placed for the single judge?
My lord, this was not placed, but this was quoted in that Supreme Court judgment, St. Mary case, where the learned single bench relied also. My lord.
Rajkumar.
On that day, it was a short circuit hearing. Lordship was a single bench heard the matter a short moment, all of us, and reserved for judgment.
What do you mean by short circuit hearing?
Well, there was a short hearing was there, but
short circuited or
well, there was a hearing, no doubt. Hearing was there, but it was in a hurry, man. Hurry.
Okay.
The court understood that reserved the judgment, man.
okay? Yes.
May I come to the relevant para? Para 23, madam. Para 23. Madam, may I just start from para 20 with lordship permission? Madam.
Yes. Yes.
Coming to the question of relief of reinstatement and back wages, in view of the factual metrics of the instant case, we have taken note of the fact that the approval of the concerned authorities was not obtained, and stigmatic order of dismissal was passed in the most arbitrary manner. It is not in dispute that no departmental inquiry was held. May I travel down to 23? In the present case, the employee has served for 5 years before the dismissal from service by a stigmatic order passed without holding inquiry. We cannot entertain the submission raised by the learned senior counsel for the appellant school that back wages should be denied. The manner in which termination had been made was arbitrary and order was illegal and void, and thus back wages followed. So this one also recognized teacher, where it was recognized the school is one of the paramount point there.
But it was so different. But would the judgment be applicable?
But out here,
Because if you're looking at stigma, it's a totally different.
but here
It's
also
a totally different footing altogether. Stigmatic orders are passed. I mean, if you're not given a chance of hearing, then that's a different thing. The stigma has been cast upon you. But if the anyway, this is next.
here I'm trying to bring that
No, we understand.
approval,
Yes.
approval part. Another citation, my lord, that with regard to, my lord, the
Civil appeal numbers.
the
Yes.
the division bench, my lord, a division bench judgment rendered in the Lahore High Court, my lord, taking into account this one of the latest judgment, my lord, may I just please. This is more or less similar with the present case. It's a recognized school. They have taken the plea of a non-maintainability, my lord. May I just start from para 3. Para 3.
Para 3.
My lord, when the matter came up before the learned single judge, preliminary objection was raised by the appellants that services of the respondent number 4 who was working on the principal, boss of principal is an unaided recognized college, had been terminated by the impugned orders and such, and his services are not governed by any statute. The dispute is a private one between the Committee of Management and the respondent number 4, and as such the appellant institution is unaided. The terms and conditions of the services of respondent number 4 are not governed under the provision of UP and such, and therefore there is no correlation between the public function and public law. It is also contended that as the institution is unaided, same does not come under the purview of Article and such. Strong reliance on such St. Mary's education. Submissions made pertaining to maintainability were contested by the respondent number 4 inter alia with the submission that the institution in question is a recognized intermediate college, and provisions of Act of 1921 and regulation made thereunder are applicable. It was also further submitted that the services of respondent number 4 are governed by the regulations specifically meant for teachers of unaided recognized schools, named such and such. Further submission were made that sections and such of the Act empowers the state government to pass an order or take such or other action consistent with the provision of the Act as it deems necessary, and therefore it cannot be said that no public element was involved. Reliance was placed on the judgment of the Honorable Supreme Court in Power Sunset, the one with it.
The only please just now.
Yes. After hearing the parties, learned single bench by the impugned order came to conclusion that the institution was a recognized college. Recognition was granted under sections and such of the Act. In view of the fact that the procedure was prescribed by 2000 for appointment of teachers, such institution could be termed as having the status of state within the expansive definition of such of the Constitution. The judgment in the case of St. Mary's Education Supra was distinguished on the ground that in the said judgment, the institution was a private, unaided school. However, in the present case, the same was unaided recognized school under the Act of Sunset. Further, by following the decision in the case of Sunset, the preliminary objection about maintainability was rejected. My Lord, learned counsel for the appellants made vehement submission that the controversy in the present appeal was clearly covered by the judgment in the case of St. Mary's Education Society, Supra, wherein it has been categorically laid down by the Supreme Court that unaided private schools, though affiliated to CPSC, is not state within the meaning of Article 12, and therefore the determination made by the learned single judge is expressly contrary to the said judgment. Further submissions were made that insofar as the judgment in the case of Sunset is concerned, in the said case, the private school was receiving grant in aid from the government, and therefore the said judgment had no application to the facts of the present case. Learned counsel emphasized that the recognition granted by the state is only for the purpose of preparing candidates for admission to the board's examination as defined under Sunset. With reference to Regulation 2000, submissions were made that a bare look at the regulation would reveal that the same only provides for qualification procedure for selection, disciplinary proceedings, termination of services, and resignation, abolition of post. And there is no interference in the appointment and termination by the state government. The same by itself cannot bring in involvement of public element. Learned counsel emphasized the case was covered by the judgment in the case of such, para number such. I come to number 9, my lord. Learned counsel for the respondents made submissions that the plea sought to be raised has no substance. It was submitted that as per the issue pertaining to maintainability only has been decided, the appeal prefer against the said order is non-maintainable as the learned single judge is yet to decide the petition on the merits of the dispute. On merits, it was submitted that in view of the provision of articles and such of the Constitution, the institution in question, despite unaided recognized institution, is performing an essential public duty, and therefore the same would fall within the definition of such. Learned counsel submitted that the definition of an institution under the Act of 1921 encompasses both aided and unaided institution, and that once the recognition is granted under the Act of 1921, the institution cannot claim itself to be not amenable to judicial review of this court under articles and such. It was submitted that the Regulation 1010, which are clearly applicable to the appointment of the respondent, clearly brings the respect of termination of service of part-of-time teacher within the realm of public element, and the submission made to the contrary is no substance. Learned counsel submitted that the judgment of full bench of this court in such and such has laid down that private institution imparting education to students from age of 6 years onward, including higher education, perform public duty, primarily state function, and therefore is amenable to judicial review of the High Court and such of the Constitution of India. And therefore the plea raised in this regard has no substance. It was prayed that the appeal be dismissed. We have considered the submissions made.
So you kindly come to paragraph 18.
Para 18, madam.
Yes, where the clause dealing with termination of services.
Yes, madam.
Which are relevant.
Madam. Para 18.
How can we read clause 9 of the regulation
madam.
in para 18?
Madam. Para 18, my lord.
Yes,
the state has issued regulation.
Direct at the other part which has been quoted, clause 9 regulation.
My lord, which page, lord?
In para 18 only, see of the clause dealing with termination of services, the first paragraph, para 18, and relevant for the present is clause 9 regulation, which reads as under. How can we read
that?
This?
Is running page, lordship, excuse me.
Page,
paragraph 18 of this judgment itself.
Yes. Paragraph, it started from state has issued regulation.
You're right. I mean, just come down there. What's clause 9? Is given which language?
Yes, ma'am. But the language is given in the Hindi.
Then, how do you understand it? Whether this termination clause covers the case?
My lord, if we read with subsequent para 19 and 20, my lord, it is very clear, with our permission. A perusal of the above provision would reveal that the same provides for termination of services wherein inquiry is required to be made, and most importantly, clause such, it has been provided in case part-time teacher is aggrieved by the decision of the management, he can file an appeal to the concerned district inspector of schools within a period of 2 months from the date of receipt of the judgment, and decision of the DIOS would be final. Clause sunset provide the committee would be bound to follow the decision of the DIOS, and regulation further provide in case the same is not followed, action under the provisions of sunset can be taken. The very fact that the regulation which have been framed under the provision of sunset 1921 govern all aspects of engagement of part-time teachers and engage the decision of the management pertaining to termination, an appeal is provided to the IOS. Besides the fact that it cannot be said that service conditions are not regulated by the statutory provision. The interference of the state through the IOS in case of termination is very much there. The distinction which was drawn by the Supreme Court in the case of St. Mary Education Supra in relation to judgment in the case of Marwari Milo regarding the appellate authority being the committee of the school itself, and state had no role, is not applicable as in the present case. Not only an appeal has been provided to the DIOS, and its order has been indicated as final, and further, in case of a non-compliance, action under such is prescribed, which clearly distinguishable the case of St. Mary. Non-compliance, if any, of the order of the IOS result in action under such. Therefore, it cannot be said that the action of termination is not governed by the statutory provision, and the same does not have any public element. In view of the above, the entire action of termination cannot be said to be within the realm of private contract between the appellant institution and the respondent number 4, only so as to make the action not amenable to jurisdiction under such. My lord. In view of the above, my lord, it cannot be said that a single judge committed any error in coming to conclusion that the writ petition is was maintainable, though for a slightly different reason, there is no substance in the present appeal, and the same is therefore dismissed.
Okay.
So, my lord, here also, my lord, the statutory obligation is casted upon the authority. With this, my lord, may I cite the act, my lord. The act. First, these are the before, my lord, the Meghalaya School Education Act came into being. With
Yeah.
regard to, my lord, appointment of the employees' condition of the TVC school, Assam rule was there, my lord. Now, I relied on the Meghalaya School Education Act 1981. Because of my entry, my lord, my entry is the class 11 and 12, my lord. And this is pointed out by the other side also, that I was never appointed for a lecturer degree level. I entered in class 11 and 12, high school, my lord. Now, may I come to the definition, my lord. Section 3.
Yes. In this act, under the context, otherwise.
My lord.
Yes.
Aided in grant in it, my lord, it is, my lord, the school is, with regard to the writ petitioner, writ appellant, there is no grant. But the college itself is receiving, that is undisputed. Further. Now, may I come to employees, my lord, definition employees. Employees means teacher and every employee working in a recognized school. My lord, recognized school. It didn't say, my lord, aided school. Therefore, employees working in any recognized school is also governed by this act.
So your this judgment will cover it, you mean?
My lord,
If it's unaided but it's recognized, that means it'll
Yes.
come under the, amenable to registration.
Yes, yes.
That's what you want to say.
my lord, I get the, my lord. I am grateful, I'm grateful. Now, existing employee, my lord, definition.
Yes.
Also they means an employee of an existing school who is employed in such school immediately before the commencement of this act. Now we come to educational institution, my lord. The next page, Roman 10, we can see. Educational institution means a recognized school, my lord. Now management committee, minority school is over there. For minority school, my lord, I'll point out in this act. For minority school, the contract service is executed between the minority school and the teachers. And termination others is governed by that contract of service. But with regard to other recognized private school, my lord, contract is not there. Contract service is not there. Now, private school may go at the bottom, my lord. Private school means a school which is not run by the central government, state government, a district council, or any other authority designated or sponsored by the state government. Now, recognized school, my lord, the next page, subsection would be 20.
Right.
Recognized school, my lord, means a school recognized by the appropriate authority. My lord. Now, teacher, well, now the recognition is started from section 4 onwards, how to obtain the recognition.
Okay.
Now, I'll come to, my lord, school, my lord. Before I proceed further, Lordship, kindly take the pain to see 21, my lord, school, definition of school.
21.
My lord, that, yes, subsection 21 of section 3, my lord.
But
School.
Clause is, okay, sub 21.
School includes pre-primary, primary, middle, and high school. My lord, class 11 and 12
Yes.
includes, my lord. I'll show the rules, my lord, where the state has published. Now, with regard to, my lord,
We have no quarrel with the definitions. I mean, it's fine. The only thing is that you want to show that it's a recognized, aided institution, right?
yes,
So we have no quarrel. With these provisions, no quarrel. We don't have to elaborate.
okay. Then I'll straight away come to the provision for termination. My lord.
Yes. Yes.
My lord, I become to
So
section...
no quarrel, no quarrel.
Section 9,
We can't recognize no quarrel.
I'll
No quarrel.
come,
I mean, if
yes.
you don't, yes.
Well, I'll
Now
come to the
you're-
provision
you're-
for termination.
Yes.
Yes, straight away to that point. Lordship, kindly see section 9. And that running page of compilation book is page number 27.
To put the EC again. Yes, 9.1.
The state, my lord, terms and conditions of service of the employees of recognized private schools. My lord, the state government may make rules regulating the minimum qualifications for recruitment and the condition of service of employees of recognized schools, provided that neither the salary nor the service condition of an employee in the employment of an existing school, recognized school at the commencement of this act shall be varied to the disadvantage of such employee. Subject to any rule that may be made in this behalf, no employee of a recognized private school shall be dismissed, removed or reduced in rank, nor shall his service be otherwise terminated except with prior approval of the competent authority. Any employee of a recognized private school who is dismissed, removed or reduced in rank may within 3 months from the date of the communication to him of the order of such dismissal, removal or reduction in rank, appeal against such order to the prescribed authority. Where the managing committee of a recognized private school intends to suspend any of its employees, such intention shall be communicated to the competent authority, and no such suspension shall be made except with the prior approval of the competent authority. Provided that the managing committee may suspend an employee with immediate effect and without the prior approval of the competent authority, if it is satisfied that such immediate suspension is necessary for reason of gross misconduct within the meaning of such and such precepts and such. Provided further that no such immediate suspension shall remain in force for more than a period of 30 days from the date of the suspension, unless it has been communicated by the to the competent authority and approved by it before the expiry of the said period. Matter. Nothing contained in such and such shall apply in the case of minority school. And, my lord, where the intention to suspend or the immediate suspension of an employee is communicated to the competent authority, it may, if it is satisfied that there are adequate and reasonable ground for such suspension, accords its approval to such suspension. Every employee of a recognized school shall be governed by such code of conduct as in
You are
prescribed.
not concerned with suspension, isn't it?
But
In your case, there is no suspension.
My man.
What is your case? Termination, removal, or dismissal, what?
It is the termination matter.
Where is the termination order?
There is, I'll show my lord. There is no termination order, but they communicate to me that my service is done away with because of the non-existence of the.
What is your condition of appointment?
There is no such matter. There is no such. And
No
it is-
termination order, no condition of appointment.
my man, I'll just show one provision regarding this contract of service, where the earlier senior counsel said that is my relationship with the school is based on contract of service. Now, contract of service is provided under this, my lord. Lordship, may kindly see. My lord, may kindly see section 13 for minority school.
Minority school.
Well, so only for minority school, my lord, contract of service will be entered between the employees and the management,
Yes.
not the recognized other private school. Therefore, the contention advanced by the school or college that my relationship is based on the contract of service. That is illegal.
Then which way we decide what is the condition of your service?
My
Which
lord-
way we get an idea about that?
But therefore, my appointment, my lord, the conduct of the party, conduct of the employee would show that I have been appointed in a regular sanction post.
And the stipulation there, conditions of
My lord,
service?
it is not that. Therefore, I will show that 1997 judgment where there is no appointment letter issued, but they can be considered as a permanent employee. I'll show that judgment.
Charles was trying to, I mean, because of the lack of any tangible appointment order and also a tangible termination order, so what it's trying to impress upon this court is that by the conditions of service that is going under, there's no written conditions, but the kind of duties assigned with all the trappings of regular employment were there. And so if the trappings of regular employment were there, you should have been given, due process should have been taken. That is your case, right? Yes.
Therefore, Lordship has pointed out the terms and conditions of my appointment.
Yes.
That is my grievance from the beginning. Therefore, to ascertain that one, I urge to the management repeatedly That did not go well with the, my lord, eyes of the management at the end. Therefore, it was, my lord, the termination took place. Now, before I cite that 1997 judgment about the deemed confirmation of service, my lord, may I come to this, the same rule, my lord. I'll supply, my lord, the rules framed by the state government, my lord, 2013 rules. With regard to management, the recognition. Because other side may say that no, the class 11 and 12 of the college will not govern by the 1991 Act. They may say, therefore, I refer to this, my lord. Definition, my lord.
This is?
My lord, this is a recognition rules, my lord. I'll come to definition, my lord. Subsection then of section 2, higher secondary school. My lord, my lord, it is,
Subsection 10 of section 2.
my lord, may I
Higher
start,
secondary school means an institution.
may I start from the
regular
beginning, my
process.
lord.
Yes.
Whereas the recognition of secondary and higher secondary school rules, Sunset was published on Sunset, inviting views and comments from the public within 30 days of Sunset. Whereas further no view and comment from the public has been received by the government after the stipulated period. Now, therefore, an exercise of the power conferred by Section 31, read with such of Section 4 of the Meghalaya School Education Act 1981, the Governor of Meghalaya is pleased to make the following rules for recognition of secondary and higher secondary school, namely. Now, may I come to 10, my lord, subsection 10. Definition of higher secondary school means an institution which provides regular course of studies in class 11 and 12, as prescribed by the board leading to the higher secondary school living such. My lord. Managing committee, governing body was provided. My lord. To a limited extent, I am quoted that, my lord, higher class 11 and 12 also governed by the 1981 Act. My lord. And therefore, the section 9 casted upon the requirement of approval, prior approval, before my termination in whatever manner, my lord, is a statutory imposition, and therefore it was very much, my lord, lie before my lordship jurisdiction. That is the points I want to emphasize. But this with regard to class 11 and 12. Assuming that, my lord, with regard to degree level, my lord, admittedly 1981 Act is not governed to degree level. Now, for devisits employees, there is another rules issued by the government, my lord.
What is your plea? You will be protected or you will be covered by which rule?
My lord, with regard to class 11 and
Which
12,
you have given just now or rule you are about to cite now? Which
my
one?
lord, it is governed by board. With regard to class 11 and 12, teachers to remove other taking action, it is governed by 1981 Act. And with regard to degree, my lord, any removal as a lecturer or assistant professor, my lord, I'll come. My lord, for devisits, aided colleges management rule is there.
Mr. Sagrish, just say
My lord,
one thing.
yes.
What is the distinction between a private school and private recognized school?
My lord,
What is the distinction between a private school and a private recognized school under 1981 Code 1981?
private school, my lord.
Private school and private recognized school.
My lord, if the school is not recognized, there is a provision in the same Act.
Who recognizes? What is the difference between a recognized private school and the private school?
My lord, it says, the Act says, my lord, if the school is not recognized, then the moment the Act of 1991 arrived, the school must obtain the recognition. Otherwise, they cannot function. Now, the moment authority recognizes, then it becomes a recognized private school. And after recognized private school, that recognized private school is eligible to receive grant in it. Until unless the school is recognized, they don't entitle grant in it also. So therefore,
It means a recognized private school is entitled to receive grant in aid. That means like all schools will have all school will get granting aid, all private schools.
No.
All
Well, under the Act, it says merely acquiring the status of recognition under the Act will not entitle the recognized school or private school to obtain the grant in it. There are certain conditions to be fulfilled. Therefore, recognition is one, but the grant in it is another. The grant in it. So there are many schools who are recognized school and did not have the grant.
and there cannot be any unrecognized school.
There cannot be unrecognized school.
So it means a private school has to be recognized.
Yeah, it has to be recognized.
There cannot be
Yes, my lord is correct. My lord is correct.
No, but then if you have you seen the definition of private school in the Act?
My lord, there is no my lord, if I
Please come, section 3,
section 3, yes.
18, subsection 18, Roman 18.
Yeah, Roman 18. Private school, my lord.
Yes,
Yes,
read it.
private school means a school which is not run by the central government, state government, district council,
Any
or
other
any
authority.
authority designated census.
Yes.
My lord, this is
There, it shows that there at least private school can exist. But then only thing is that it is not run by any of the state government, or central government, the district council, or any other.
my lord. And now, therefore, this private school cannot independently function without recognition, my lord. It requires recognition, my lord.
Where is that?
My lord, come. We come to the recognition rules. Submitted. Just come to that.
Recognition rules came in 2012.
My lord.
2013.
2013, my
No,
lord.
prior to that.
Well, prior to that, my lord, I did not come across the particular specific rules. But if we go by the 2013, it requires a recognition.
No, what we are interested to know, whether a private institution, which is not run by any of the, not run or managed by the government, can exist or not.
According to me, my lord, it cannot exist.
Why?
Why it cannot exist? Because the student has to, the classes has to be recognized. My lord, if I open a school today,
Recognized by whom?
my lord, if I open a school today, and without any recognition by any authority,
No, you take
No.
affiliation of the board, which would be definitely under some different
my lord, the affiliation to other unit like CPSC, I may go without recognition
So
from.
once you have affiliation, that means you are recognized. So far as your students are concerned, they can appear in exams and all.
My lord, that is for the purpose of affiliation, for the purpose of, my lord, the examination for the students. Not for the, my lord, regulating the service condition of the employees. My affiliation to CPSC, for example, is with regard to legitimize my imparting education to the students.
Now you say this institution
Yes.
where you are working,
Right.
it was a recognized school.
My lord.
On what basis on you say it is a recognized school?
My lord, it is a recognized school, my lord.
Because how
My
do
lord,
you know?
if it is not recognized, my lord, they impose the examinations.
That is where this
My
court
lord.
is exactly asking.
Other they cannot face the exam. Metric they cannot face the exam.
Okay.
That's application. That's application. There are two different things, government recognition and application is different. That's a separate thing. Recognition, yeah. That was bifurcated from the Interim school. So that is why he can't but he will not be able to explain that. He cannot do that. He is saying. He cannot explain. He cannot explain. What he's saying is right. Generally, you continue, yes.
Well,
It's just that with that part,
Well-
because we understand the difficulty you have, because the thing is that with the bifurcation and whether it's a school or it's a college, we will be difficult to explain. So you please proceed, yes.
Well-
That's also just because we're airing our minds.
yes, yes, well, great, well. My lord, what I'm trying to bring home
Yes.
is that the school recognized under the Act is a statutory recognition.
No, don't confuse
And-
the school and the college again, because you'll be going back to bifurcation. The thing is that now your appointment is that you are trying to put your feet on two boats. That at the same time there's a school after bifurcation and 12, same time you're teaching the college section, so you'll be governed by aided college. So we can't have that. Now we just go by your term, by again, like what my brother said. What are your terms of engagement? Where everything stems from your terms of employment. Now all your rights will flow from there only. Like where's the initial appointment, what are the conditions? Your difficulty, you understand that there's no terms of employment, you're just floating, and then like now you're trying to draw all these things together to say that yes, I was regular employee, treated like employee for all practical purposes, and so I should be given the benefits of a regular employee. That is it, right? Yes.
Well,
Yeah.
now with regard to class 11 and 12, the reason I pointed out
Yes.
is statutory recognition. And with regard to degree level, where I have placed one rules.
Yes.
My lord, that 2013 rules, my lord, Meghalaya Division Aided Colleges Management Rules, 2013.
Right.
Lordship, when we see the definition of employee, Lordship, may I please? Section 2, my lord.
Yes. Yes.
My lord. Employee means every person employed in an education institution whose entire salary is drawn from maintenance grants received from the state government, except MENAIL, that all employees covered by grant in aid. The governing body, I'll come to the dismissal, how to dismiss, my lord. May I come to, my lord, section 23, page number 6.
So the thing done 309 or whatever they did. Yes. This will be made under the some. Yes.
My lord, we come to section 23, my lord.
Yes.
Subsection 9.
Yes.
To
23(9).
appoint, my lord, the power of the governing body.
Appoint staff.
To appoint staff and other persons that is necessary to run the affairs of the colleges after due advertisement and interview. All such appointments shall, however, be made in conformity with prevailing relevant rules governing the appointment. No such approval is necessary in case of appointment of substitute teacher maintained by the college from its own fund, provided, my lord, provided that such teacher possesses the required qualification. No such approval is necessary in case of appointment of persons in the MENAIL category. Well, may I just pause here. There are two sets of employees. Those who in the women college itself, those teachers who receive grant in it is governed by this one. Those who did not, my lord, receive any grant in it, my lord, for those people, my lord, approval is not required. It's absolutely with the managing governing body. Now, the governing body shall adhere all the procedures prescribed under the relevant employee rules approved by the government in the matter of dismissal.
No, a substitute teacher only.
But
Let's see. You see, in case of appointment of substitute teachers maintained by the college from its own fund, but such no such approval is necessary.
But for substitute teacher, my lord,
No such approval is necessary in case of appointment of substitute teachers.
my lord,
Yes. Yes.
may we read separately, my lord. The governing body shall adhere all procedures prescribed under the relevant employee rules approved by the government in the matter of dismissal of any incumbent holding a post under the visit funding system. In case of other categories of employees, it's important, my lord,
Yes.
employees, the principle of net justice and equity should be adhered to. my lord. So with regard to college level, we are governed when it comes to dismissal, my lord.
Natural justice should
Natural
be
justice
followed.
is a requirement. Is a requirement.
Okay.
But,
Anything else?
so therefore, my lord, only the citation
Yes, you
1997.
can write the citations, yes.
My lord, lordship put a
You
question.
spend enough,
Yes, my lord,
yes.
my lord, put the question: what is the terms and condition of my appointment? That is the crux, my lord. Now, since my lord, the employer is always in the upper hand, he has a better bargaining
Who?
ground. the employer always.
Right.
Therefore, the employee is always in the receiving end. Therefore, non-issuance of a confirmation order, well, that cannot be the ground for termination of any other employees. My notice relate to banking officer, 1997 volume 7, ACC, page 550. Relevant para, my lord, may come to para 7, 8, and 10. Though this banking officer, he was appointed probation, and he was absent for many years, and he came back, and he claimed for service, court turned down, but the law was laid on that. Para 7, my lord. The above quoted last extract on which reliance was placed by the High Court, and on such emphasis was laid by Sri K.K. Vinogopal, General Counsel for the respondent, has to be read in the context, not divorced therefrom. In substance, Sanjay Singh held that where the service rule permitted continuance in service as a probationer beyond a certain period, an express order of confirmation is necessary to give the employee a substantive right to the post. And the mere fact that he is allowed to continue in the post after the specified period of probation is not sufficient to hold that he should be deemed to have been confirmed. But where the maximum period of probation is provided in the service rules, and the employee is allowed to continue in that post after completion of the maximum period of probation without an express order of confirmation, he must be deemed to have been confirmed in the post by implication. It is significant that the effect of permitting the employee to continue in the post.
Sorry to interrupt. What analogy are you trying to draw from this judgment?
My lord, here analogy, my lord, I want to say that I was appointed, my lord, and to other teachers, other.
No, analogy from this judgment. I mean, the analogy. What you want to draw from this?
My lord,
Why the probation doesn't come to your case at all? Yes.
My lord, here in my case, the petitioner was allowed to continue to teach, and the conduct of the employee showed that he has given the permanent status in nature by the conduct.
Okay.
And therefore, the Supreme Court emphasized the conduct of the employees. May I just come to that portion?
Damages.
Well, I'll come to 8, para 8 straight away. It is obvious that the decision sunset can no longer applicable in a case where the employee was absent from duty from a date much prior to the expiry of the maximum period of probation and remained absent even thereafter for a long time. There was no occasion in such a case for the employer to allow the employee to continue to work on the post after the expiry of the maximum period of probation because he was absent and was not working on the post at the time of the expiry of the period of probation. Team confirmation results from the conduct of the employer in permitting continuance in service after the expiry of the maximum period of probation fixed by the rules. When there is no such conduct of the employer, the very foundation for the equivalent of a team confirmation and reliance on such is not existent. In our opinion, this discussion alone is sufficient to indicate that the High Court has dismissed sunset to grant relief to the respondent. However, we may refer to the same later decision also to indicate that it is the correct position in law. Since such there was no maximum period of probation prescribed in the rules, and therefore it was held that there could be no automatic confirmation. As Seven Judge held that provision regarding the maximum period of probation was directory and not mandatory, and such matter. There can be no doubt that the team confirmation which is inferred from the employer's conduct is permissible only when it follows from the positive act of the employer, permitting the employee to continue to work on the post even after completion of the maximum period of probation permitted under service rules, since no other inference is possible in such a situation from the employee's conduct of continue to take from the employee after that period. I'm trying to draw, my lord, that the conduct of the employer giving me permanent status.
Yes.
That amounts to confirmation. Team confirmation. The last one, St. Mary's one, but I'll not drop her. It is distinguishable. St. Mary's one, it relates to affiliation to CBSE. And CBSE affiliation is not stemmed from the statutory regulation. It's just only a bylaw. Therefore, the fact of the case involved in the St. Mary's Education Society is only a person, the staff terminated, affiliated to CBSE. Supreme Court held that CBSE bylaw has no statutory flavor, and therefore you cannot derive. Therefore, you cannot enforce the Article 226. In my case, my lord, statutory flavor is there, my lord. So this is my humble submission.
Yes. Who's appearing for the respondents?
Ashok, I appear for the respondent
Main,
college.
main answering respondent.
Lordship.
Main answering respondents whom state any role to play.
The role is very limited.
Mr. Manta appearing for?
I'm for ambush.
And Mr. Sen for Nihu. Yes. How long will you take? 10 minutes.
Lordship. My case is very brief, Your Lordship.
Yes.
Lordship, first of all, Lordship, there was no post advertised.
Yes.
So if there was no post advertised, obviously there was no interview and there was no appointment. This is an admitted position that there has been no appointment letter which has been issued to the appellant, Your Lordship. Now, my learned friend has been arguing at length, Your Lordship, and referring to rules which pertain to college and also pertain to, so perhaps there is a bit of an identity crisis here. Because if I may start off with his writ petition, Your Lordship. In the first para of his writ petition, he claims to be an assistant professor in the Department of Computer Science. May I take Your Lordship to the first para of his writ petition, which is at page 48.
Yeah. From the
Lordship, he claims that the petitioner is a citizen of India and was serving as an assistant professor in the Department of Computer Science at the Respondent Women's College.
yes.
But soon in para 7, he himself claims at page 51, Your Lordship, that the writ petitioner begs to state that though having regularized against the college sanctioned post with regular pay scale, the respondent college never issued any appointment letter to the writ petitioner, and as such, in the Staff Council meeting dated 28 May 2016, besides other agenda issue, the issue of non-issuance of the appointment letter to the writ petitioner was considered, and accordingly, the teachers' faculty, by letter dated so-and-so, wrote to the respondent governing body expressing their dismay and sorry state of affairs to know that all the faculty members under college sanctioned post has all received an appointment letter except the writ petitioner. So his case, Your Lordship, is that even in 2017, is that there is no appointment order.
Yes.
Lordship, he claims that in 2011, he was appointed as an assistant
Professor.
lecturer, Lordship, in the Department of Computer Science. He himself goes on to show, Your Lordship, he has referred to some documents in his writ petition, Your Lordship. Lordship, page 80 is this letter dated 22nd July 2017. So, Lordship, if he has been appointed in any post whatsoever in 2011, why is he writing to the principal of the, I'm asking myself, Your Lordship, why is he writing to the principal? The undersigned takes this opportunity to communicate to the concerned authority to consider my tenure of service from 20th June 2011 as a faculty in this institution in the Department of Computer Application.
These are all admitted documents. There is no dispute about this.
Lordship,
This document
His
is,
document.
this is
this is his documents, Your Lordship. This is from his writ petition. So here in 2017, Lordship will kindly note why I'm referring to this is, he says, as a faculty in this institution in the Department of Computer Applications, and provide me my appointment letter. So there is a serious confusion, Your Lordship, because the Department of Computer Studies is very different from a Center for Computer Application. In 2017, he says, I have not got my appointment letter to the Department of Computer Applications, which is only in the higher secondary section, Your Lordship. Now, Lordship, he has referred to a salary certificate which he claims has been issued by the college, Your Lordship, which is at page 71. Now, Lordship will kindly note, and again, this is a document in his writ petition, December 21st, 2015, Your Lordship. This is a salary certificate. Lordship will kindly also note the conduct of the appellant, Your Lordship. He has a salary certificate in 2015 where it says that certified Mr. Ajit Paul is serving this college as a full-time lecturer in the Department of Computer Science since 20th June 2011. In 2017, he himself writes, so it is for him to explain which is the correct position as per these two documents, Your Lordship. If he has a salary certificate as a full-time lecturer in the Department of Computer Science, then in 2017, why is he writing to that very same college saying that I am serving in this institution as a faculty in the Department of Computer Application and kindly give me my appointment letter? And as I had pointed out in para 7 of his writ petition, Your Lordship, he claims he has been regularized. My little understanding of service matters, Your Lordship, that there has to be an appointment which can be confirmed. He admits there is no appointment as late as in 2017. So how can he claim to be regularized prior to his appointment, Your Lordship, in whatever post? So the contradictions are glaring, Your Lordship. He has referred to many rules where the terms and conditions of his service are defined, he claims, Your Lordship. Terms of service can start only from the date of appointment to a certain post, in my humble understanding, Your Lordship. There is no appointment. He claims till 2017 there is no appointment letter, but he also produces a salary certificate. He claims he's paying, this provident fund is being deducted from his salary.
According to you, what was his status in your institution?
Lordship, according to me, what was his status is again clarified by him only, Your Lordship, by all the certificates which
But
he has
you do
annexed.
not have a contention. You do not have a say of your own that what is his status.
Lordship,
What was his status?
Lordship,
You are not denying that he was a part of your institution for some time.
Lordship, he was, Lordship, there are time to time computer literacy courses which are offered in the college. So he was conducting those computer literacy programs.
As?
Lordship, the certificates themselves are, in what capacity he was doing, his certificates will show, Your Lordship.
And
I'll
why
just-
does the principal issue the salary certificate?
Lordship.
Why does the principal issue the salary certificate?
Lordship, this is, Lordship will kindly appreciate in 2015, how can there be a salary certificate, Lordship, when he himself claims there is no appointment?
Whatever is but signed by the principal,
Lordship,
to
that
show
is,
there was some term of engagement, some kind of engagement was there.
unfortunately, Lordship, I think it was the goodness of the college that he was trying to be accommodated and given a salary at par with the other teachers. That is the only, I think, in my submission, the mistake made by the college, which is now trying to take benefit of, Lordship. But Lordship, to reply to the query from your Lordship, in what capacity he was serving in this college, Your Lordship? Lordship will kindly come to page
Can you clarify my correct-
89.
Can you present my status for my- Can you clarify my present status for my-
Lordship, may I read? This is 10/7/14. May I read, Lordship?
Yes, yes,
Page
please.
89. This is a letter dated 10/7/14 to Ajit Pal, Department of Computer Application. The undersigned would like to request you to kindly conduct coaching classes under the year 2014 for civil services banking staff selection examination. Under the integrated UGC-sponsored service, entry-level coaching classes to be held at Women's College, Shillong. The classes are scheduled to commence from so-and-so, so-and-so. The remuneration will be rupees 250 per class. Lordship, these are annexed by him, and this is not an isolated one, Your Lordship.
Yeah, we've
Page
seen
nine-
that earlier, yes.
Page 91 is the letter dated
But is it not
22/6/2015.
something in addition to his regular duty?
Lordship, there was no regular employment. As and when whatever these small-time courses or coaching classes that he was doing, Your Lordship. And this is on his own admission.
Then see the address. This is Mr. See, in the
Lordship.
manner which you addressed, Mr. Ajit Pal, Department of Computer Application.
Lordship, there is no department as such of computer application. And if it is a department of computer application, Your Lordship, then it is a regular post he's holding. If he's holding a regular post, Lordship, my humble submission is, how can he be conducting coaching classes for UGC, staff selection? And it is not an isolated incident. Lordship, 14, 15,
But
page
then,
93,
he was
etc.
conducting as a resource person. See, subject of your letter.
Lordship, that is why I'm saying, Your Lordship, if he was a regular teacher in this college, Your Lordship, then he will not be doing these kind of.
No, as a resource person.
Resource person you call everywhere.
But this is in our college, because he claims he is serving in our college, Your Lordship, as a regular employee.
Because there's a special courses which are being run, and so that's why he's roped in as a
Lordship.
resource person, and he was paid a remuneration 250 as
Lordship.
incentive to hold the classes.
This is buttressed by the submission of my learned friend, when he says that after he's no longer with the college, Your Lordship, and there was a query at some point of time by Your Lordships that is there any such computer application department in the higher secondary section, Your Lordship. That is answered by my learned friend when he referred to the 2020 NEP.
Prospectus.
Yes, Your Lordship. Lordship, that will be at page 229. Which he now claims, he himself claims, now it is called a Code Your Website. Now, Lordship will see what are the other such courses: basic accounting, Code Your Website, geriatric care management, photography as career, sound art, ultimate beginning to guitar, learning to speak Hindi, content creation. So this is his own submission, Your Lordship. Earlier, these were the sort of courses which were offered, which now, under NAP, these are the courses. The computer courses which he claims to be teaching, Your Lordship, is now called Code Your Website. So these are short-time certificate courses, Your Lordship, which is offered time to time by these institutions as almost like extracurricular activities, Your Lordship, not a regular course.
Yes.
Now, Lordship, the fact that what was under challenge in the writ petition is his so-called termination order, Your Lordship. Lordship will kindly look at the so-called termination order. My humble submission is, this is, Lordship will find that at page 100. Lordship, this is dated 14 December 2019. The appellant writes an email to the principal. Dear sir, has Your Lordship's got it? Page 100. Yeah. Dear sir, with reference to my email to you dated 29/10/19 and 10/12/19 respectively, I would like to request you yet once again to clarify my current position in the college. Today being the last working day in the college for the current year, I would like you to currently clarify the same so that it becomes easy for me to understand my future in this institution. Lordship, a regular employee who has been appointed, regularized way back in 2011, writes in 2019, kindly clarify what is my position in this college and what is my future in this institution. And this he claims to be the termination. The reply to this is the termination, he claims, Lordship. Dear Mr. Ajit, I was of the opinion that you had been informed by the teacher's representative of the governing body's decision to do away with the department in the college, as it never started as a separate department in the degree section. As of today, the department is not there in the college. This was to his knowledge all along, Your Lordship. Which is again pointed out by my learned friend, Your Lordship, in page 334 of his, because way back in 1995, Nehu has made this very clear. Nehu says so, Lordship, I am not saying it. And my learned friend has been kind enough to point out this document, which actually I had missed, Your Lordship, because I was referring to a current document. Lordship, page 334, may I read again? This is a Northeastern Hill University notification, Your Lordship. dated 14 June 1995. In accordance with Section 5 of the Nehu Act 1973 and meeting in line with the national pattern of education and on decision of the Executive Council and Academic Council of the University and with concurrence of governments of Meghalaya and Mizoram, the Vice Chancellor is pleased to transfer the pre-university level of education currently affiliated to Nehu to the respective State Board of Secondary Education Government, effect from the commencement of the 1995 academic session. Lordship, this is further reiterated, Lordship, which was placed by Nehu before, sorry, not by Nehu, Your Lordship. This document was placed before the learned single judge, Your Lordship. I had given that compilation. Lordship, page 3 of this.
Yes, given it. Yes, yes, yes. It's there in the
Lordship,
file.
this is
Yes,
dated 1/4/2019, Lordship. This is from the Executive Chairman of the Meghalaya Board of School Education to the Principal of the Women's College. Approval regarding delinking of Women's College Higher Secondary section from the college. I am to inform you that the board acknowledges the delinking of higher secondary from the degree section of your college, and the name Women's College Higher Secondary has been put in our records. So, Lordship, this delinking is by the concerned authorities, Your Lordship. The higher secondary section is delinked, and not only in the Women's College, it's throughout the state, Your Lordship. The
No, no. Maybe in the emboss. Actually, he can't answer. Yes, he cannot. Actually, he can't answer things. There's no term of appointment. He can't answer. There's no point in continuing with him. Anything else?
So, Lordship will kindly see that there is no appointment letter, there is no termination, there are no rules that is governed by. So, I'm not replying to all the
Will
details
examine.
that my learned friend
Yes,
has gone
Mr.
into.
Manta, anything else?
My point notice here submitted.
Yes, I mean, yes. Mr. Shulai,
No relief, I can just clear your mind.
Mr. Sen.
So for the university will only the repeated query from the whether that particular department was affiliated. I'm checked over it was not. College is affiliated, but that particular every department also is affiliated.
Yeah, affidavits on record before the single bench.
One letter has been given.
That's at page,
Oh, that-
page 1 of this compilation, Lordship. Will kindly
And
note, the Nehu letter is at page 1.
The post held by by direct appellant is neither government sanction nor aided.
No, that is clear. Yes. Okay.
Judgment itself
Happy?
is written.
Yes, right. Judgment reserved.
Obliged.
There's no time to pass an open court. We've taken enough time.
Obliged, Lordship.
And Mr. Shankar is on a valiant job. Yes.
Any
Yes.
mention? Any mention?
Yes, Your Lordship. Lordship, I beg to mention item 25. Your Lordship, I pray for 2 weeks' time, Your Lordship.
25.
Yes, Your Lordship.
Any urgency?
No, Your Lordship.
No urgency. It's after 3 weeks, yes.
Obliged, Your Lordship.
Yes.
Lordship, I beg to mention item number 31 and 32.
30?
31 and 32, Your Lordship.
Yes.
Your Lordship, here that we're awaiting a report. A meeting was held on the
Where's the
13th.
petitioner?
She's here, Your Lordship.
What happened to the hearing?
Lordship, because we were already
concluded?
attended. Concluded, Lordship.
When was it concluded?
And
Your
just
Lordship,
recently
we have no
also.
instructions because the inquiry is still going on.
MS that in our country, GA, please will have to obtain specific instructions as to the outcome of the hearing before the Deputy Commissioner. Yes.
Obliged, Your
This
Lordship.
after 2 weeks, yes.
31 and 32, Your Lordship.
May I please, Your Lordship, I beg to mention item number 33, Lordship.
Yes.
Your Lordship, I'm waiting some instruction from the petitioner, Lordship. So
Why you want to withdraw the matter?
no,
What's the matter about?
Headman. It's a headman matter.
Headman doesn't survive more than 6 months. What happened?
Lordship?
You're sitting headman or you're ousted headman?
Sitting headman.
Then why do you file a case?
Your Lordship, there was certain complaint against me.
Then?
So I've come against those complaints,
What happened?
fearing that
Lordship, the inquiry was stopped in view of the petition.
Why the inquiry was stopped?
I had no idea, Lordship.
Why do you want to do the hearing?
Lordship, I'm seeking certain instruction from him regarding that
1
complaint.
week. Okay. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 35, Your Lordship.
Yes. Where's the petitioner?
I've already informed them.
Why?
The conducting counsel is not available today, Your Lordship.
conducting
Mr.
counsel?
SM, Your Lordship.
Lordship, no objection, Lordship.
2 weeks, yes.
Obliged, Lordship.
I beg to mention item number 23, Lordship.
Number?
23, Lordship.
2, 3.
2 weeks, Lordship.
Why?
I'll take some instruction, Lordship.
What's the
Only
other side? You taken consent? No.
the government, Lordship, only the government. part.
Government no consent mean, not free.
She is representing, Lordship.
2 weeks, okay.
2 weeks.
Item number 20.
22 matter. After? Tomorrow?
No, Lord. 2 weeks. 2 or 3 weeks.
2 weeks. Yes.
Maybe, Your Lordship, I beg to mention item number 22.
Number?
22,
Is Otun.
Your Lordship.
Other side?
I've already informed the KGC.
I understand. Where's the other side out in the court? This is a council. No one's there. How long? 2 weeks?
2 weeks, Lordship.
Yes.
Your Lordship, 24 as well. 24. Item 24. 24.
24.
Yes, Lordship.
Other side?
I am for petitioner.
You have no objection?
No.
Yes, 3 weeks, yes.
Alright.
Oh, your petition, 2 weeks, yes. 2 weeks, yes.
Lordship. Lordship, I beg to mention item 34 on behalf of
Number?
the petitioner. 34, Lordship, 34.
Yes.
Hearing for 2 weeks' time, Lordship.
No objection, Your Lordship.
3 weeks time.
2 weeks, Lordship.
Take 4 weeks.
2 weeks'
Any
time.
urgency?
2 weeks, Lordship. This is regarding that death of in July, Lordship, with the car fell
Death
down
of the
the
doctor,
cliff,
Your
Lordship.
Lordship.
2 weeks.
2
yes.
weeks' time, Lordship.
Obliged, Your Lordship.
Yes.
Item number 30.
Number?
30. Your Lordship, I pray for 2 weeks' time.
For 3 weeks time.
2 weeks' time.
Let it be 3 weeks, Your Lordship.
Any urgency?
No urgency, Your Lordship.
He's retiring soon.
Yes, Your Lordship.
You said you're going to bring some material
Lordship,
saying
yes.
that his
Lordship,
conduct-
yes.
Who's
There
the
are place.
petitioner?
DK Datta.
There are place, Your
Where's
Lordship.
the Datta?
He's indisposed, Your Lordship.
There are all place, Your Lordship. Even
Hearing
the
stopped last we were hearing this matter.
Lordship.
You stopped the hearing. He said that I would bring some materials. To show
Lordship,
that
yes. That it's ready with me. It's ready with me. And I've pleased your Lordship how the fact also have been twisted, your Lordship, from the pleading in the earlier writ petition and in the present writ petition. That also I'll place it before your Lordship.
2 weeks.
Yes, Lordship.
Lordship.
Yes.
Highly apply, your Lordship.
Yes.
May it please
My
your
lord,
Lordship. May it please your Lordship. Lordship, if I can mention item number 26, my lord.
Yes, other side.
Mr.
Changreshwar?
There. Yes, my lord. Yes, my lord, this is that Shillong Club matter. Lordship may recall on the last occasion, Lordship had stated
some reservations. Yes.
had some reservations, my lord.
Yes.
I confirmed with the appellant. Lordship's clan has indeed leased out about 6 acres to the club, but my lord, that is under a completely different lease agreement, and it's a completely different property. My humble submission, my lord, would be that that should not come in the way of Lordship taking up the matter. Of course, subject to whatever Lordship decides at the end, my lord. But there should not be any impediment as such, my lord.
Okay, we'll take it up when you come personally, just on Monday. Yes.
Very good, very good. Obliged.
Lordship, I beg to mention item 36 on behalf of NC.
Item?
36, Lordship.
36.
Lordship,
the whole list is gone.
Slight objection, my lord. Kindly fix it, my lord, in the on Monday, my lord. Urgency, my lord. The transfer matter.
On behalf of whom?
Lordship, N. Syncon. Due to some personal
Although mention has
difficulties.
been made for adjournment on objection of Mr. S.K. Hassan. When you want it? Tomorrow?
Tomorrow, my lord.
Tomorrow?
Lordship, kindly let it be next week.
Monday, my lord.
Monday, yes.
Hello.
Obliged, Lordship.
may it please, Lordship.
Yes.
Lordship, I'd like to mention item number 37, my lord. And for the petitioner, due to some difficulties, my lord, I cannot be there today. My lord.
No objection, Lordship.
2 weeks, yes. Yes, follow the list.
My lord, I beg to make a mention of item 21, my lord.
Enough adjournments, yes.
Some difficulty today, my lord, if it is taken up any other day.
Yes, Mr. P.T. Sama. What's the matter about? What's the matter about?
My lord, this is regarding
Most of
scale.
these matters, they won't take more than, yes, half an hour, yes.
Lordship, there is a notification whereby the senior employee, when they were upgraded to the
This is regarding scale, my lord.
the scale, then
Yes.
they're supposed to pay the equal salary to the scale to the junior employee. That is the whole case.
You're serving in which post?
Now I'm already got retired, Lordship. That has been filed
1 week, yes.
Lordship.
Don't take time unnecessarily. Yes.
Obliged, my lord.
Followed.
Supplementary list, item number 1.
Please ask me before motion.
Mr. Shila's comment.
Yes, see, yesterday while punching the order,
Lordship, yes.
then while correcting the order, I realized that
Lordship.
substantial documents have been brought on record. Without, I think elaborate orders are necessary in this matter. Because, Mr. Shilla, we can't allow this situation to continue. So we have to pass
Yes, ma'am.
corrections. And we have, the court has seen from the documents provided
Lordship.
by the state, that there has been attempts,
Lordship, yes.
but then there's some quarters or something which are trying to, disable the entire process. In spite
Yes,
of
my
the
lord.
overtures and meetings done by the SDO and all, there are
Yes,
some
my lord.
elements which are still trying to, for whatever reasons they have, and from what I
Scuttle,
can see
your
from,
lordship.
from the. So what I want the state to do, at least put this on affidavit, if you can file it by day after tomorrow.
Lordship, kindly excuse us.
Why?
A week's time may kindly be.
No,
Or
because
we'll
this
try,
matter
your
needs
Lordship. We'll
urgent,
try, your
needs
Lordship.
urgent,
If Lordship,
attention.
Yes,
You
my lord.
can't have this kind of every tourist place
Lordship, just a minute,
where they,
please, Lordship. If Lordship can, on till 27, your Lordship.
you only have to put it in a form affidavit. They just annex them and index them and file them. But then the court can take proper notice
Lordship,
of
yes.
the.
Lordship
of
will
the
try,
steps
your
that
Lordship.
have
We'll
been
try
taken.
our best, your Lordship.
Because yesterday when we passed the order,
Lordship.
I realized I was looking through them after the order had been passed. I was while correcting the order that that there's been many efforts. Not only one day.
Yes, my lord.
on many dates.
And
In
in fact, that there was even undertaking that they will hold a darbar, they will connect the
Yes,
key.
Your Lordship.
I know, to make the whole thing, so that the whole
It
thing may
started
not be
from
jeopardized.
12/6, Your Lordship. That meeting started from 12/6 till 12
for
July.
2 months.
We can't
Lordship, then I'll do it, Your Lordship. I'll
You
do it.
kindly
My lord,
take
and
back.
yesterday some disturbing things were also there, my lord. It's reported that there's open defecation in this entire stretch, my lord.
No, those things will take care. We'll list it on.
Yes, my lord. Yes.
You please come personally as a fixed matter. We'll pass orders on the day.
Lordship,
But
yes.
only put
Yes,
it
yes,
on
ma'am.
statement.
Lordship,
Yes,
yes, we'll do
we'll
that.
go on record. Okay.
Yes, we'll do that, Your Lordship.
Yes,
We'll do,
ma'am.
certainly we'll do that.
Matters posted clarification today, and as much as on the last date, certain documents had been submitted by the by the Additional Advocate General, which have a great bearing in the matter. In order that effective orders be passed, the learned senior counsel is requested to file the said documents by way of an affidavit. Is the matter on 27th?
27, Your Lordship, yes.
27. We'll file before that.
Apply, Your Lordship.
Very disturbing. I mean, it's just for money.
A solution has to be found, Your Lordship.
No, we'll pass orders from here. Anybody
Lordship,
who
yes.
disturbs, then they will be taken.
Lordship,
Then it'll be taken to task.
Apply, Your Lordship.
Obliged, my lord.
Yes.
Please, Lordship. This is the second round of litigation, Your Lordship. What happened in the earlier round of litigation, whereby this Lordship, this court has passed an order directing the inquiry GHDC to conduct a fresh inquiry and to report it to the matter, and if required to conduct a fresh election, Your Lordship. Now, what happened on the basis of the direction of this honorable court, they have issued a notice for conducting the fresh inquiry. Now, in the inquiry, what happened, Your Lordship? There is irregularities. Number one, the date was fixed, the specific date was fixed, and after that, they have set up the time. The time was actually by 2 o'clock. Now, the officer, instead of conducting an inquiry, not 2 o'clock, 11 o'clock. Instead of conducting an inquiry by 11 o'clock, they have conducted an inquiry by 2 o'clock and without any information. And secondly, there was in the inquiry, Lordship, they have maintained one register. One register means like they have asked all the participants to register to write their name in that attendance sheet, and later on they have distinguished in the two parts, divided in one supporting for the holding an election, another supporting for not holding the election, and to continue with the interim Gangbora that was appointed by. Now, to that effect, Your Lordship, the complainant, the private respondent, the petitioner hearing, has filed the complaint, strong complaint, with regards to the irregularities of the manner in which the inquiry has been conducted. And then it is not known to the petitioner also how these two groups were divided. They have stated that one group got another 89 something like that, 85.
How many of the people? How many people supported
actually
you?
They're as per their
inquiry. I'm not saying real supporters.
89.
As per the inquiry,
yes,
and
around 89.
how many supported private respondent?
They supported 114.
So that means a sort of election is already held.
It is not an election. They said that was the election. They don't say the election, but since there are a number of people supporting the.
Okay, we'll direct that election be held by secret ballot.
Yes, Lordship, and there is a lot of various judgment also from this court, and from the.
Of course, we should. But that'll be if this is the way that meant by head counting, and
yes,
it'll not work. Nowadays,
he says that in the inquiry,
and moreover, there
because
was
of
no
rain, his
verification.
supporters
The
had
election
gone.
idea also was not
rain,
verified.
because of rain, supporters went away.
The inquiry was held. Majority support was in favor of the private respondent. Thereafter, he filed a representation before the deputy CEM, saying that actually he had around 200 supporters, but most of them went away because it started raining heavily. So his supporters could not be. And
No,
this case lordship gave us
Anyway,
instructions.
Mr. P.T. Sama has issue notice. Mr. S. Dev Vice SD's President accept notice on behalf of Response 123. Notice issued on before within 3 AD.
Lordship.
The list After 2 weeks, yes.
Lordship. Actually,
It
I
takes
have
steps.
mega prayer to
No
stay
interim stay.
Lordship, yes, Lordship. Much obliged, Lordship.
He's in office, right? The respondent.
Yes,
And moreover, he's a teacher actually.
So
Private
teacher
student.
can't.
There is
But the
there is
headman
a
is.
statutory bar.
Daily list,
Last-
item number
There's a
1.
bar.
Yes, Lordship.
Yes. Yes.
Here the respondents were required to file a list of preliminary
Where's
witnesses.
the witnesses? Yes, MS Pallavi.
Issues were filed on the last
Where's
date
the list of
itself.
witnesses?
Your Lordship, so far list of witnesses are concerned, Your Lordship, because they have to lead evidence. So once they lead the evidence, then we will file the list of witnesses. Because, Your Lordship, this is what we are following in the election petition too also, Your Lordships. So that is the
Fix a
reason,
date for
because
deposition. When? Huh? We have issued summons.
Also,
No,
we have filed the
issued
list along with the designation and the address.
Your Lordships, today issues have to be framed, Your Lordships.
As far as the preliminary issue, Lordship, of presentation, witnesses, Lordship, would be the stamp reporter, the advocate, and the
No,
petitioner.
we have to. You have furnished the list, correct?
Yes, we have filed them.
Yes,
Furnished
let's
the
see.
list, Lordship.
Take it to the list. And the issues? Yes. Draft issues. Okay, take down. But the election petition as well as the respondents. The petitioner as well as the respondent number.
Only one respondent.
Respondent, only one respondent, Your
have
Lordships.
filed their suggested issues. Stop. Court examined the same. And the preliminary issues are as follows. Take down. The preliminary issues are to be taken up as follows. Take down. Whether the election petition has been presented personally by the election petitioner, the stamp reporter, in accordance with Section 81 of the Representation of People Act 1951, read with Chapter 8A of the High Court rules as adopted by the High Court of Meghalaya. Whether the election petition is liable to be dismissed for not being accompanied by copies of the election petition attested by the petitioner under his own signature to be true copies of the petition as per Section 81(3) of the RP Act. Whether copies election petition filed before the court and supplied to the respondent are identical nature. Yes. Next page. Deposition when? Because we have to supply the addresses and summons have to be issued.
Lordship, we have supplied a list of preliminary notice along with the full address of the
Addresses?
along with the address, Lordship.
Is there? You have 1, 2, 3, 4. Five witnesses.
5 witnesses.
Yes. Yes, next paragraph. Let summons be issued. You don't have any official witnesses?
Lordship, at number 5 is she's the stamp reporter.
No, official witnesses, sir. Or only one? Yes, let summons be issued. You can finish all of them in one day.
Lordship, if I may pay for 2 dates, we'll.
Let summons be issued to the witnesses. Dates will fix in the summons itself when they have to appear.
Lordship.
Yes, over 2 dates. For the position to be recorded from which date?
Whatever convenient, Lordship, we are willing.
Now it's September. We'll have it on September. Second week, okay. 11 and 12. Yes.
Please, Your Lordship. Your Lordship's evidence affidavit has to be supplied to us in advance.
Yes. They have to file that.
Yes.
That's understood.
Please, Your Lordship.
Yes.
Grateful, Your Lordships.
Yes.
Item number 2.
Yes. File.
May please, Lordship. Lordship, we filing course of the day, Lordship. We've served a copy on the other side, Lordship.
Course of the day is from 26/7 till now.
Lordship.
Where is
Lordship.
the petitioner? Course of the day is 26/7. Mr. H. submits that we'll find a course of the day.
Just now I have received my copy. Anyway, my lord, we'll just
What about
go through it.
Yes. 6 to 10, 15 to 18, yes. You're filing? No. Waiting for?
I'm appearing for the private respondent, Your Lordship.
What is this matter about?
This is regarding, my lord, the seniority. Seniority of the writ petitioner vis-a-vis the private respondents. Do the same writ petitioner enter service much before the private respondent?
Okay, Mr. H. submits that the affidavit. We file a course of the day. The same plea had been made on 26/7/2024. Yes. You'll file rejoinder?
Reply if any, my lord. I will go
through. It's a matter of 2 weeks for rejoinder, if any.
If any.
I reply.
And yes.
2 weeks time may be given to file our
Yes, and 2 weeks further time, and also 2 weeks further time granted to the respondent so and so for affidavit. Yes.
I oblige.
Item number 3.
Please, Lordship, I'm appearing on behalf of D. Nandi, Mr. D. Nandi. Lordship, he is unable to present today because of Bharat Ban, Lordship.
The Bharat Ban today?
Yes, Lordship.
So, when next date when?
May this matter take up after 2 weeks, Lordship.
Okay, mention will be made on behalf of Mr. D. Nandi, counsel respondent who is not available today due to personal difficulty.
Lordship, only the interim order was.
Yes, just a matter of 2 weeks. Interim order, if any, shall continue next date. Yes.
Much obliged.
Ms. Hassan wanted to argue this matter actually.
Item number 4.
What you prevented him, I think. Yes. Yes.
Lordship, we have received instruction and praying for 2 weeks' time, Lordship.
Course of the day.
2 weeks' time, we'll file it positive.
2 weeks, yes, for affidavit. For that time, it's free.
Obliged.
Item number 5.
This is Lordship. This is Contempt, Your Lordship.
Who's appearing?
My friend is.
Compliant.
Lordship, got instructions that we are complying, Lordship. There is still.
You file affidavit.
Lordship.
Mr. H. Karuna is entered appearance on behalf of the respondents today. So service complete. Just after 2 weeks for affidavit.
May please, Lordship. Lordship, if one thing also, since the finance department and there'll be some.
Put an affidavit, whatever difficulties you have.
Yes. Lordship.
Item number 6.
Much obliged.
Your Lordship, we are entering appearances for respondent number 5.
Number 5.
We already filed the power today. Your Lordship, I'm for respondent number 4.
Yes.
I'm for respondent number 4.
Where's the affidavit?
My apology, Your Lordship, we couldn't file the affidavit.
Why could not find?
We are adverse to the matter being.
Yes?
We are not adverse to the matter being taken to the tribunal.
Very good. We have seen submission. You have your objection to the matter being taken to be remanded back to the competent authority. Mr. Manta?
Just during appearance today, I think.
You will take instructions?
For respondent number 5.
Yes, Mr. S.P. Manta, Liz Counsel, along with Ms. Elian Thankyos, entered appearance on behalf of number 5. As such, notice complete on the respondents. We pray for the 1 week's time to appear instructions. Kindly see the earlier orders pass.
Next week it can be disposed of. I think there's a tribunal.
Yes, it's a tribunal. Is that the 3 villages?
Yes, sir.
You're supporting the case. You're supporting. Or if it is the council. Yes.
Item number 7.
Much obliged.
May it pleases your Lordship. Lordship, items 7 and 14 are analogous matter, your Lordship. We need
Where's
time
the petitioner?
In this matter, we have filed the affidavit, your Lordship, but in item 14, we have not filed. We need time, your Lordship. 2 weeks
None
time.
appears for the petitioner. Mr. Shulai submits that affidavit has since been filed.
Lordship,
No
yes.
one appears interim order, then it will get vacated. No one's there for the petitioner. Number 9023. You file the affidavit. Who's Mr. M.R. Marak? Take the none appears the petitioner. Mr. Nishulai, AAG, for response 1 to 8 submits that the affidavit since been filed. Z. Begum, you haven't filed it. When are you going to file it?
After 2 weeks.
MSZ Begum for 9 to 20 pays without further 2 weeks time to continue. Stop.
In item number 14, Your Lordship.
What one none appears, then interim order is till next date. Yes?
Then 14, your Lordship, is same matter, your
Yes,
Lordship.
together with so and so.
Lordship.
Affidavits.
In that matter also, I'll be filing my.
Yes, this is so and so. Respondents will file affidavit for the next date.
Apply, your Lordship.
Yes.
Item number 8.
So I'm praying for a week's time for my affidavit. Send it for signatures.
Number 4 is whom?
Number 4 is the headman who was appointed. He is chosen
No one
not to
there.
appear.
By order dated 26/7/2024, has been recorded that if no representation was made on behalf of number 4, the matter shall proceed ex parte against him. Stop. Today also there is no representation as behalf. Only matter shall proceed ex parte against number 4. Stop. Next, Mr. S. Deb, please follow out further. 1 week's time. The file after yes. This thereafter and so and so.
Obliged.
9.
Ex parte is number 4.
Obliged.
Yes.
Please, Your Lordship.
Yes.
Lordship, it seems that there are certain settlement talks going on between the petitioner, Lordship, and it seems that the matter is going to get settled. So I seek some time, Lordship, so that if
The Joshi submits as a settlement talks. He prays matter after
3 weeks, Lordship.
3 weeks. Yes. Is that correct?
I don't have any instruction.
But I had instruction from my petitioner.
Item number 10.
Declare, please, Lordship.
Lordship, in pursuant to the order passed by this court,
You file affidavit.
we have sent a reminder to them, Lordship.
What reminder? Who's
we
the
have contacted
officer
We have
concerned?
contacted the Divisional Soil Conservation
matter
Officer.
It's a pension matter. It's a grade 4.
We'll ask him to come here in court, then if we don't get instructions.
Lordship, we've contacted them. They have contacted us. They are preparing.
I'm not interested in that. I want an affidavit on board next date. Mr. G. Thaba submits that he has, that affidavit will be filed positively by the next date. This up to 2 weeks. You better file it, otherwise the officer will be in trouble. Yes.
Item 11.
Yes.
Lord, in this case, the RBI authority has filed an affidavit, Lord, in this case.
You received copy?
No, my lord, I'll serve the copy right now.
You have you filed it, or you're in the process of filing it?
No, we are filing today, my lord. After serving the copy.
Has Harika, right? Yes, for respondents 8 to 10 submits that the affidavit will be filed in the course of the day. What about the other?
Lordship, so for
47?
We'll rely on the affidavit filed by the bank.
Yes. Then you want to file a joinder?
Yes, Your Lordship.
This after 2 weeks for the joinder, if any.
Interim order.
Interim order pass election continue next day. 11. 11. No one appeared last time. No, last time there was no appearance in last day. Anyway, submit that the state response as also going to rely on the affidavit filed by the bank.
Item 12.
Deeply understood.
May I please, Your Lordship? Lordship, I am appearing on behalf. I am appearing for the petitioner, Lordship.
Yes.
Lordship, the matter pertains to the non-payment of the salary, Lordship. And Lordship, since November 2023, the salary of the petitioner is on hold, and the respondent is supposed to file the affidavit.
Lordship, we'll be filing the affidavit in course of the day. Lordship, we've already served the copy to the.
Mr. Karanlang submits that affidavit will be filed in the course of the day, and advance copy has already been given to the council. This is the matter next week. Yes. Next week we'll dispose it of.
Lordship.
Yes. Much obliged, Lord.
13.
My lord, 8 respondents are there. None of them have filed their affidavits.
Your Lordship, on behalf of the state respondents, Your Lordship, we have some difficulty because the SSA staff are on strike, Your Lordship.
Please, Your Lordship, I'm appearing on behalf of respondent number 7, Your Lordship. Your Lordship, I seek some more time, Your Lordship, to file our affidavit in opposition, Your Lordship. Why? Your Lordship, we need to seek.
We have taken steps on the 8.
8? You filed? Let them list a matter of 2 weeks to enable the respondent to file respective affidavits. Yes.
Obliged, Your Lordship.
Item 15.
Please, Lordship. This matter, Your Lordship, the respondent number, we have served a notice to respondent number 3 and 4, Your Lordship.
Not yet received. Yes, officer indicates that service is not complete
They are appearing for.
with regard to response 3 and 4. Yes. Yes?
Your Lordship, we've been instructed to appear on behalf of the private respondents.
3 and 4,
for the agency also, Your Lordship.
Agency?
3 and 4. Director of Meghalaya
Yes,
New
Your Lordship, 3 and 4.
Okay. MSZ in home country today submits that they will be entering responsive half of responses 3 and 4. As such, the notice is complete. Yes.
I pray for some time, Your Lordship, to file affidavits in this
Please
matter.
allowed 2 weeks' time to file affidavit. Similarly, similar prayer made on behalf of respondent 1 and 2. Yes. This after 2
Lordship,
weeks for
this
affidavit.
item number 15 to 18 analogous, Lordship, safe.
19.
Must please, Lordship.
The reply has been filed to the miscellaneous application, my lord. Today morning only, my lord.
What is this?
This is with regard to, my lord, blacklisting.
Oh, yes.
Blacklisting and uh, seeking recovery of money from
You received a
the.
copy?
My lord, I have received a copy, my lord. Now, my lord, I've gone through the affidavit filed with them, my lord. My lord, in fact, they admit that there's a breach of contract, my lord.
On their part?
On our part.
On my part.
Even if we take at the face value the reply, my lord, the only contention in the affidavit, when they elaborate their order, my lord, the impugned order, they say that there was a breach of contract on our part, my lord. Now the question, my lord, before your lordship, for a breach of contract, simpliciter, my lord, what are the remedies? When there's a contractual remedies are provided under the contract, my lord. The contract says, my lord, if there is any breach, they can issue a 30 days notice and terminate the contract, my lord. Now, in these circumstances, my lord, they blacklist us, my lord. Now, my lord, blacklisting has severe consequences for us, my lord, because there are ongoing tenders right now. I've annexed along with my petition, my lord, and we are not able to participate in those tenders. We are a 200 crore turnover company, my lord. We have operation not only in India, in several other countries, my lord. Now, this has caused a civil death of the company, my lord. I'll only place one decision, very recent decision of the Supreme Court, my lord, if lordship permits, my lord.
Yes, of course.
And my lord, why this date is after my blood, my lord? If we have done something wrong,
And they have been after my blood, my lord. They have given something which was junk. We have not used. The state has suffered. Public interest has suffered, my lord.
So that is a breach of contract, my lord.
It's not a breach of, and it's a breach as well as gross violation of the terms of the contract, which entitle the authorities to blacklist a company.
What is this?
May I request for citation of the case, citation, so that I can take out the judgment. Citation only, please. I need citation.
This is a decision rendered by the Honorable Supreme Court very recently, my lord. In fact, 7th of August, just last week, my lord, 2 weeks back. In para 26, my lord, if lordship kindly sees, my lord.
What is the title of the case, Mr. Dr. Mojika, please?
Blue Dreams Advertising. Para 26, my lord.
26. Blacklisting is a bit severe, yes.
My lord, it says, my lord, para 26.
But it is permissible in law, my lord.
Of course. What is the permission?
What are the parameters, my lord? The Supreme Court has laid down, my lord. In other words, where the case is of an ordinary breach of contract and the explanation offered by the person concerned raises a bona fide dispute, blacklisting debarment as a penalty ought not to be resorted to. Debarring a person, albeit for a certain number of years, tantamounts to civil death, inasmuch as the said person is commercially ostracized, resulting in serious consequences for the person and those who are employed by him. Now, my lord, if your lordship kindly takes out the affidavit filed with them, my lord. Para 3, my lord. First, I'll draw your lordship attention, my lord. It says, my lord, that it is submitted that the petitioner has no prima facie case so-and-so, that the petitioner in breach of contract, terms of reference, failed to execute the project and delivered an unusable application and incomplete management information system. Then, my lord, lordship kindly sees para 8, my lord, that it is submitted that the terms of contract only when providing a functional and acceptable application and completion of 1 year of operation from the date of full steam operationalization, that the maintenance and held-holding period of 36 months commences, and the petitioner was entitled to payment in terms of schedule of payment under so-and-so, that the petitioner wrongfully raised invoices before completion of key milestones in contravention to the terms of contract. Now, my lord, your lordship recollects on the last occasion I pointed out, the period of contract is 43 months, my lord. And now, what they say, my lord, on the next page, your lordship kindly sees, they specified a table, my lord. My lord, on the next page, your lordship will say, they are saying that the third year will be complete on 19/11/2025.
Yes.
Our case is, my lord, the 43 months of the contract was signed in 2019, my lord. So, yes. July 2023, the contract period is otherwise also over, my lord. My lord, the project was for 5 years, my lord. The project is funded by World Bank. The project itself is over, my lord. There is no question of our contract subsisting till November 2025, my lord. So, my lord, what I'm trying to submit, my lord, that all these are contractual disputes, my lord, and there is a remedy provided for that. There are claims and counterclaims, my lord, and the arbitration clause provides that either of the party can make a reference. Now, without doing that, my lord, without following that procedure, my lord, what they do, they blacklist us, my lord. So, my lord, at this stage, what I'm praying, my lord, but that is, otherwise there is nothing substantial in the reply. I've gone through the reply, my lord. They are only saying that the breach of contract. They are saying that we raised the bills before time, my lord. If we raised the bill before times, if you admit what they were doing, my lord, they were the persons who passed our bill and made the payment, my lord. It's not that I went to their treasury and took out the money.
So-called has been sued the officer. He has left and so-called also has been sued to the officer who is colluding with the respondent.
So, my lord,
I
in any
will
case,
place everything.
My lord, my case is that if they are entitled to any compensation or
who's the officer who's colluding
for breach of contract, my lord.
Assistant project officer, my lord, he has left and he has in several cases done it. And we have issued so-called also, my lord. Let my turn come, my lord. I will place everything.
Blacklist him also then.
We are taking action. We are taking action, my lord. If necessary, we have to file a FIR and we will do that also.
So, my lord, at this stage,
Because this is not one case where we have found this kind of
if they are entitled
misappropriation.
to any compensation, any monetary
Misappropriation.
In monetary terms from us, my lord, there is a remedy for that. We are willing to participate in any proceedings.
And this is also
but
a remedy.
Blacklisting at this stage, my lord, when there are bona fide contractual dispute, my lord, in my humble submission, till the final affidavit, the matter is heard, because we are suffering on day-to-day basis, my lord. And this is disproportionate action taken by the government, my lord. So I'm praying for only for an interim stay, my lord, till the matter is heard, so that we can participate in other tenders.
Yes, Your Lordship. Now, Your Lordship, kindly see the first submission with regard to the period of the contract, my lord. Briefly, Your Lordship will notice.
No, please address whether, according to them, it's disproportionate, the action taken. That if you, even there's any breach of contract, then you have like adequate remedy to to rectify it by resorting to the terms of contract itself, which they are bound. They're saying that now they by blacklisting them, you've inflicted civil death on them, not only with regard to the specific contract, but with regard to all other, the entire company.
Now, the two things are very clear, my lord. My friend is admitting that there is a breach of the contract.
Yes.
Second, what my friend is submitting, breach will not entitle.
Let's see. Volume.
The terms of contract.
What my friend is saying, that breach will not entitle the authorities to blacklist the company, my lord.
Yes.
My lord,
this is
to blacklist, there must be some element of criminality, my lord.
No,
without criminality, there can be no breach, my lord. If I understand clearly, the law or the proposition which is being advanced, that blacklisting will take place only when a criminal action is taken, or FIR is registered against the company, my lord. Now, without going into all this, my lord, one short judgment is of Supreme Court, my lord, is of 2014 SCC 731, my lord.
One second. Your citation?
This is 2014 SCC 731.
731 sounds. What's the name of the parties?
Kulja Industries Limited versus Chief General Manager. But, my lord, before let me place few facts also, only for 2 minutes, my lord. Kindly see my affidavit. Kindly see my short affidavit to the stay application, my lord. Very short, my lord. I'll just read those 2-3 paragraphs, my lord. Kindly see paragraph 4, my lord, of my affidavit. And then I will place the Supreme Court judgment and including blueprints also, my lord.
This decision has been considered in
paragraph 4. The application, paragraph 4, my lord, the application developed by petitioner was sought to be used for project planning, preparation of village natural resource management plans, performance monitoring, and geospatial analysis. However, application developed by petitioner was replete with multitude of issues and that rendered it entirely unusable. It is submitted that respondents were not able to utilize the application as envisaged in the terms of contract. It is submitted respondent was compelled to hire independent data entry operators to manually enter data due to the complete failure of the application developed by petitioner and it is being unusable. 6, my lord. It is submitted despite manual entry of data using independently hired data entry operators that inherent issues within the application rendered it unsalvageable. That it is submitted, respondent was subsequently compelled to abandon the application entirely and to engage another third party for developing a fresh application. It is submitted that unusable application developed by petitioner is caused failure or execution of the project that has caused monetary loss and disrupted the entire planning process of the respondent, my lord. Now kindly see with regard to period, my lord, that it is submitted under the terms of contract only when providing a functional and acceptable application and completion of 1 year of operation from date of full stream operationalization. That maintenance and hand-holding period of 36 months commence, my lord. So 1 year plus 36 months, and that period was entitled to payment in terms of schedule of payment under clause 14.2 of the contract. Petitioner wrongfully raised invoices before completion of key milestone in contravention of the terms of the contract, my lord. Now, my lord, paragraph 9, that the following facts would bear out the impugned order is appropriate and petitioner has no prima facie case for grant of stay. It is submitted that on 16/12/2019, the parties entered into the design, development and development of ICT-based MIS to support the implementation of Meghalaya Community Landscape Management Projects for a period of 55 months. It is submitted first 7 months were allocated to the development phase. The next 12 months were for deployment and operationalization phase, and only after full completion of both development and phase 36 months would have commenced, my lord. 36, so 48, my lord, and 7 months, my lord, they completed in 13 months. So 25 plus 30, 61 months, my lord, because for 7 months could not be completed in 7 months period. That chart is there at paragraph 9.2, your lordship may kindly see. 16/12/2019 is the paragraph 9.2. is the date of the contract. 1911 start of deployment phase, start of maintenance and hand holding phase, my lord. The expected date of first half yearly report and raising of corresponding invoice raised on, my lord, 15/2, my lord. The 19/5 is the date on which invoice should have been raised. They raised the invoice much before and in collusion with one of the officer who has now left the organization, and so-called notice has also been issued. We are collecting all materials, my lord. 1911 expected date of second half yearly report and raising of corresponding invoice raised in contravention of 15/2/22, my lord. Then third expected date of third half yearly report and raising of corresponding invoice raised in contravention of the contract on 23rd September 22. 19th November expected date of fourth yearly report and raising of corresponding invoice raised of so and so. Now 19th May expected date of fifth yearly report and raising of corresponding, and then 19th November 2025. This is the 6-year report we have to. Now 9.3, my lord, that MIS system delivered by respondent failed to meet the contractual requirements. The application had several critical issues including data synchronization failures, frequent app classes, lack of integration with project system, missing modules related to key activities and funds, and absence of integration with Tally among the other deficiencies. It is submitted that respondent was compelled to issue order only after multiple so-called notices which provided petitioner with ample and sufficient opportunity to address and rectify the critical and fundamental issue. My lord, this was the backdrop, and there were other companies also. Other companies came forward, my lord, and addressed and removed the difficulties. This company, my lord, did not do, and this is one of the first project, my lord, of World Bank funded project where
dispute resolution clause.
Dispute resolution clause is, my lord,
page 407.
that they can invoke, my lord, that is there, that they can invoke. My question is, my lord, my submission is, my lord, contract, if your lordship will see contract at page
Let's see a
400.
resolution clause. 407.
First is 407.
400, my lord. 400 contract starts, my lord.
Right.
407 says, my lord, termination, clause 19.1.
And, my lord, therefore the question, because we have blacklisted for the after three so-called, my lord, just see so-called also, because it's not that principle of natural justice.
One second, yes.
Termination clause, my lord.
Yes.
The contract may be terminated by either party as per provision set up below. The client may terminate this contract in case of the occurrence of any of the events specified in A2F of this clause. In such occurrence, the client shall give at least 30 days, calendar days notice to termination to the consultant in case of the events referred to in so and so. There is listed out, my lord. And the arbitration clause, my lord, the lordship will find at page.
If consultant feels remedy of failure, yes, okay. Where's GCC 18? Okay, then.
At page 428, my lord. Clause 45.1. The dispute shall be settled by arbitration.
Yeah, 428 is saying.
Page 428, my lord. Arbitration clause 45.1, my lord. Dispute shall be settled by arbitration in accordance with the following provisions.
Yes.
It says, my lord, selection of arbitrator. Each dispute submitted by a party to arbitration shall be heard by a sole arbitrator or an arbitration panel composed of 3 arbitrators in accordance with the following provisions. Where the parties agree that the dispute concerns a technical matter, they may agree to appoint a sole arbitrator, or failing agreement on the identity of such sole arbitrator.
Go on to that.
My lord.
407. Have you seen the Supreme Court judgment, Mr. Advocate General?
Yes, my lord, both judgments, my lord. I'll just read out the judgment. Just now I have gone through that, my lord.
It's a 3-bench.
Yes, same judgment, my lord. Kindly see the paragraph, my lord, of 25 of this judgment, my lord. Paragraph 25. Paragraph 25, my lord. And
25, yes. Okay.
Yes, my lord. And third line, my lord. Third line.
Has been referred, my lord, in para 24.
I will read. Let
the
me
judgment
just.
cited by Advocate General is referred, my lord.
Yes, I will both the. Because what is significant, my lord, for paragraph 25, what is significant is that while setting out the guidelines prescribed in USA, court noticed that comprehensive guidelines for debarment were issued for protecting public interest from those contractors and deficient who are non-responsible, lack business integrity, are engaged in dishonest or illegal conduct, or otherwise unable to perform satisfactorily. The illustrative case set out also demonstrate that debarment as a remedy is to be invoked in cases where there is harm or potential harm for public interest, particularly in cases where person conduct has demonstrated that debarment as a penalty alone will protect public interest and deter the person from repeating his actions which have a tendency to put the public interest in jeopardy. In fact, it is common knowledge that in notice inviting tenders, any person blacklisted is rendered ineligible. Hence, blacklisting will not only debar the person concerned, but so your lordship now kindly see the parameters which is there.
These are in my favor.
I'll read. Blacklisting will not only debar person concerned, but because of disqualification, they are dealing with other entities which is also prescribed. Even in terms of conditions of tender, in present case, one of the conditions of legislative agency should not be blacklisted from anywhere. The question which, my lord, is that if the illustrative parameters which have been set out in paragraph 25, my lord, whether my case falls under this category or not. If I fall under this category, my lord, then I have shown, my lord, that the petitioner has taken money without rendering any service. I have shown, my lord, that petitioner has provided the app which is without any use. I have asked for refund of 1.59 lakh rupees. The money has not been refunded. So whether it is in public interest for me to blacklist the company or not is the issue which is before your lordship, my lord. And 25 clearly, my lord, I will just...
One thing, okay. Just now, is it a case of bona fide dispute or is it fraud?
Both, my lord.
Being played on the...
yes, it is a fraud which is it is a fraud which has been played, my lord. Fraud in the sense that if you give me a software which I have to jump and you take...
Now one thing, Mr. Arvind, is the other respondents culpable in any way for the non-performance of the software that they give?
Respondent is not at all, my lord. There is no question, your lordship. Kindly see so-called.
Is there any dispute that needs adjudication? You mean, that's what the court wants to know, with regard to
Yes,
how
my
the
lord.
contract was carried out.
No, see, so far as the entering into the contract is concerned, my lord, contract was duly weighted by World Bank, and World Bank weighted it
Fine.
because this is.
What this court wants to know is
Yes, my lord.
what has happened between the petitioner and the whatever respondents.
My lord, the simple thing, lord, as we want
have to be resolved otherwise now also, or otherwise your entire it just terminates right now without resort.
Because, my lord,
you don't resort to any other dispute resolution.
my lord, I have two things. I have lost time. I have lost
No. Are you saying that now we have come to an end? The relationship come to an end. There's nothing to adjudicate due to the conduct of the petitioner. We have blacklisted him, and we try to recover the amounts from him. Is there any element of in the contract or an execution of the contract which has gone bad, which needs adjudication to see what are whether fault can be attributed to squarely to the petitioner or no, there's something that they also can say that yes, the respondents also have some role to play in like the contract not being fulfilled.
My reading of the petition, I don't see any single amendment.
If there's no adjudication, then fine. But if there's any adjudication, that means that blacklisting will not be, it's not a good recourse.
My lord, whether it is good, bad, or ugly, but the question which is there, my lord, is whether the authority in terms of legal provision is entitled to do it or not. If my friend shows that the admitted fact is that app which was at the software MIS has failed, my lord. MIS was, and they have taken money for something which is useless for us, my lord. And therefore, and we have given three so-called notices, my lord. Just read one.
My lord.
One so-called notice. Your lordship, kindly see my page 679, my lord. 679.
679.
Yes, of the writ petition, my lord. Because we have been after this, the drastic measure, my lord, has been taken only when they have failed to do it, my lord. Kindly see the conduct. Ultimately, what we have to show to the contractors who are coming to.
Page
679, my lord.
Volume
3.
Volume 3, my lord. Volume 3, my lord.
You should spiral bind them, I think.
Annexure 29, my lord.
Six, 7,
9, my lord. Annexure 29.
Yes.
My lord, second paragraph. As has been brought to your notice on several occasions. This is 23rd February 2022 notice, my lord. Kindly mark this. On several occasions in the past, it may be ever since the aforesaid MIS was commissioned and payment for services is made thereto, MIS system has abysmally failed to deliver the agreed services inter alia, primary services like the data synchronization issues, app, etc., with the project missing models for several crucial activities and funds.
682.
Sorry, my lord, 682. Okay, 682. I also note for implementation of MIS on-site performance testing by agency post system is requirement and contract, but the same was not carried out by RMSI. And the above issues have raised with you on several occasions, and while the amount of 1,457.4 lakh has been paid to you as per contract, you have neither remedied the deficiencies brought to your notice, thereby willfully breaching the agreed terms and conditions of the further terms are under the Appendix A. Clearly specifies these are the period for which, my lord, they have to handhold, my lord, and provide this. Now, last paragraph of, my lord, page 682. It is also needless to mention that very objective behind installation of said system was support MBMA in project management, also enable important stakeholders including Government of India, Government of Meghalaya and lending institution World Bank to able to monitor the project. Hence, incomplete and non-functional installation of the said MIS project has become not only major cause for concern but also uncalled for embarrassment as well. Please, under these circumstances, as to why action should not be initiated against the organization, including but not limited to termination of contract, initiation of appropriate proceeding, recovery of public exchequer for damages caused, and blacklisting of the organization within from future procurement across all state central government within 30 days of date of issue. So this is the fact, my lord, is that this project they did not do anything. Now, I have said so. I have issued so-called notice, my lord. I will the so-called notice, and then, my lord, second so-called was issued, my lord, on 30. And my lord, let me tell you, your lordship, the one more fact. There are other companies. They came forward and remedied. We have issued so-called notice to the other companies also. They came forward and remedied.
To that effect, my lord.
And we will do that. Whatever you are saying, I'm not objecting. You are making too many oral submissions which have nothing to do with the record.
Even this is oral submission without any evidence on record.
Yes, my lord, but I will place when I will file detailed count.
Okay. First show cause
Yes, second show cause.
Second show cause.
And then 30th, my lord, 745, my lord. This is the order, second, at page 745, my lord. And that will be part of volume 4, first annexure, my lord, annexure 31.
First show cause, okay.
Volume 4.
We shall see. But one thing, Dr. Moses, is the fact that you submitted the projects before this due. I mean, raised the.
No, my lord, that's not correct. I'll take your lordship to the reply.
I'm just saying. Yes, the court is saying 6. Next second show cause, page 741.
745, my lord. And now the stand and this is there.
745, right?
5, my lord.
Yes.
And your lordship will find, because my lord, we are dealing. Let me give the backdrop, my lord, that we are dealing with a situation where companies are coming, they are contracting, and they are not performing, and we are facing similar issues in number of cases, my lord. And this is what we have to send clear message that please don't take us for granted. 4745, with reference to the response provided by RMCA, by letter dated so and so, to so-called notice dated so and so, to the office so and so, my lord, kindly, first, that mobile application did not work as intended for field functionaries from their respective villages. This has in turn caused significant hindrance, additional cost, and delay into the progress of the project and its overall rating, and affecting future prospects of the Government of Meghalaya. Secondly, the date of raising invoices were in contravention with the agreed terms as laid down in the contract signed by MBMA and RMSI.
One second. Where you didn't reply to the first show cause?
I replied.
Reply is at page 6684, my lord.
Okay.
684, my lord. Reply, I wanted to 684, my lord. And before that, my lord.
1 second, let me flag them.
Yes. And your lordship.
No hurry, no hurry.
No, your lordship, then in that case, your lordship, kindly see one more page of the contract, my lord.
1 second.
418. 418 before I take your lordship to 418.
I'm you're going too fast for the court.
Sorry. Sometimes liquid takes you fast. Liquid takes too fast.
You filed it e-filing also? Did you file by e-filing this one? No.
Now we have to have e-filing now.
For these kind of things, you better. E-filing is very cumbersome for the court also to traverse all these documents.
In commercial matters, so at least we should start having existing contractual commercial matters. We should have e-filing.
Yes, because it's easy also. Otherwise,
yes, Lord.
There is a standing order. I think that you're asked to by e-filing. Lawyers are not cooperating. You even said like first these bill applications, then be filed by e-filing be easier. So if you're going to, otherwise we're just swimming in paper.
Yes,
once my flags get lost, I won't find the page also.
And at times flags goes out of the file also, my lord. But marking a liquid test remains.
Not only
my lord,
the notes also, yes.
Yes, my lord. Your lordship, kindly see page 418, my lord, of the contract. 418, which is part of the volume, my lord, 2, volume 2. Volume 2, 418, my lord.
Yes. Which thing?
And top of the page, your lordship will see
418.
my lord. And your lordship will see the clause 2.2, small Roman 2.
Fraud and corruption.
Fraud and corruption is the title, my lord. And then your lordship may straight away come to 2.2, small Roman 2, my lord. Fraudulent practice.
Yes.
Fraudulent practice is any act or omission, including misrepresentation, that knowingly or recklessly misleads or attempts to mislead a party to obtain financial or other benefits to avoid an obligation.
Yes.
So, in my humble submission, my lord, the facts and so-called notices, my lord, will show that it is nothing but a case of fraudulent practice on their part in giving something which is junk, which is useless, and it has got no utility. Ultimately, government is forced to spend money. In fact, World Bank has come down very heavily in some of the meetings, saying that the app is not worth.
Where's the reply to this one? Where's the reply to 30th
So-called,
March?
yes, that reply you will find at 684 in volume 3.
First show cause. Now what about
First so-called is, my lord, first so-called as for your lordship at page 679, and reply is at 684, volume 3.
Yes.
Volume 3, my lord.
Yes.
Now, your lordship, yes, my lord, kindly see the response. What is the response, my lord? The response to the letter, dear sir, with reference to letter dated so and so, non-fulfillment of hiring of agency of design development, etc., Meghalaya Landscape project under so and so. We would like to bring to your notice that during the inception and implementation of phase of project, we closely work with CLLNP team and the World Bank team for the development of SRS and application. Any deviation in implementation due to non-availability of API for internal-external integrations were captured in the inception report and the SRS. MIS application was made live after training, acceptance and testing of functionalities of the developed MIS system. However, understanding the recent issues highlighted to us on investigation, the issues further we found, now they are investigating a lot, that down that few days from October 22 to November 22, server was down from October 22 to November 22. We informed that issue on 9th November 22 to Mr. Melvin as coordinator. If result services were restored back on 29th November 22, due to service being non-functional in the above duration, it resulted in piling of offline data, hence mobile syncing and other data issues were found, my lord. This is all Sam will reply, my lord. Nothing has worked, my lord. Ultimately, we have to.
What about a demand for refund? What did he say about that?
Your lordship, on-site, no, there is nothing. Our on-site resources for 2 weeks starting in 8th February 23 was tasked to understand and address the issue. Support from offshore team. Most of the issues were promptly addressed and closed, and status was communicated to so and so, my lord. Now, my lord, to integrate now the various table which we had skipped in my reply, my lord. Now, kindly see page 689. 690 bottom. Though preliminary performance testing was done before deployment of the MIS application, we will ensure that due diligence is done in regard to on-site performance testing. They are not denying that there is no problem. Regarding milestone and invoicing scheme, we would like to bring to kind notice that total duration of project is 43 months. Before your lordship, it was 36 months. Now, their own admission from the date of signing of contract on 16 December 2000 due to expiry on 15 July. Following are the actual dates achieved in the milestone, my lord. So this is the date they are there. We take cognizance of the fact that RMC work pertaining to so was appreciated in previous milestone work Appendix 7, my lord. This is the person who gave the, and against him so cause has been issued also. Therefore, we are now unable to understand the reason for non-usability of application. However, please be assured that RMCI will leave no stone unturned to provide solution of resolving any issue pertaining to functioning an application when brought to notice otherwise so and so. We would like to schedule meeting with so and so. Now meeting took place, my lord, and that which resulted in the meetings which are there, my lord, at page 745 at Annexer 31, volume 4, my lord. First document of the volume 4.
And you can continue at 2 o'clock.
Your lordship, only one document, my lord, because there is a final arbitration argument which is I will be stuck in.
Yes.
Only, or your lordship may have it tomorrow. Tomorrow, your lordship, because the.
You will follow us tomorrow because.
Tomorrow, your lordship may have it tomorrow, your lordship. Lordship may have it tomorrow.
Yes, since it's just filed, we'll have to allow to examine it. So, but you know compendium, correct? Of judgment.
And I will give my citations also.
Other matters. Yes, list for further consideration tomorrow. The blacklisting is anyway. But then you see, the only thing that's troubling the court is that if there's any element of fraud being perpetuated by the petitioner, with regard to using the bill especially, it was due on 23, was it raised on 22?
Well, there is not even an allegation of that, my lord.
Yeah, I will place the case also, my lord. I will place the case.
Was for 43 months, my lord. Now they are stretching it to 6 years, so 7 years, my lord.
I will place the relevant law also on the tomorrow.
Well, the press clippings has been given, right? Is it what? 27, 27.
27.
As per this court order on Porkin, the petitioner is present here today, your lordship.
You told him to come here forward. You're a petitioner?
Yes, your lordship.
Why you made these statements in press? No. Why do you make them? Can you? Are you trying to disrupt this the justice system? Is what do you see in the papers? Where's the press clippings? You said that the petition was filed before the High Court, and they already had more than 20 hearings. And do you know that the matter is sub judice? Why do you go and speak to the press?
Sir, I didn't say regarding 20 times, sir. I didn't say.
What is this?
I didn't say.
Now, why did you go at? Why did you at all you go to the press?
So we have a meeting in.
Why did you why did you take part in a meeting if you already filed a case?
So because I am in the forum, sir. We are in school minus 11.
What is your education qualification?
Sir, I am class 9 fail, sir. Class 9 fail.
What do you do for a living?
So I run my own fast food.
Do you know what the meaning of contempt of court? You know what means contempt? Contempt, the face of matters being taken by the court, in the face of proceedings, you have committed contempt.
Sorry, sir.
By speaking, see, mining stakeholders want SOP scrapped, then so and so, see, your name Shilla added, so and so. You're Shilla, right?
Yes, sir.
Have you seen this, Mr. Sama? Have you seen the amount of news that's come out?
I have seen, I have read also, your lordship. But
Lordship has heard the matter. In fact,
he does not have the intention to.
What intention?
Sir, I didn't mean, sir, to say anything regarding that.
What did not mean to say anything? Are you trying to, your whole case has been spoiled because of your action. You want to go to jail?
Sir, I'm very sorry.
You know that if you obstruct the proceedings of the court, you're liable to go to jail. You sat here the whole morning, correct? You've seen what the court do? Is sitting on 20 hearings.
No, sir, I didn't say regarding 20, sir.
See, Mr. Kindly show him.
Yeah, I have shown to him, sir, but he said to me, Your Lordship, that he didn't say all those things, but the paper has met.
What does that say? He said that see, what does he say? He said the petition was filed before the High Court April 27, 2023, and the court's already held 20 hearings. I wanted to file a petition as soon as the government issued notification, but not support. Now the officials have backed me, and we're fighting with the same cause, shall I add in. He informed and submitted a memorandum to Chief Minister on the issue recently, mentioning the prescribed normal SOP is contrary. He urged the government to allow minors. Are you trying to influence the court, or what are you trying to do?
So I didn't say regarding anything from the time.
I don't say you do not see it, do not say. It's covered in black and white. Are you denying that you didn't take part in the meeting? Are you denying that you didn't say anything to the press?
Yes,
Did you say yes or no?
So I didn't say regarding 20.
Yes or no, did you talk to the press or not? Then, that's enough. We'll drop contempt against him, we'll let him go to jail.
Your Lordship, I think it will be too harsh to...
What do you mean, Mr. Sama, too harsh? You should advise him also.
Yeah.
Sorry, sir.
You file an affidavit tendering a qualified apology by tomorrow. Otherwise, you can't do this. The public should know. If you brought a matter before court, and you go and talk to the press, you have cast aspersions on the function of the court. 20 hearings have been done. Do you know who took time? The takedown. The petitioners appeared in person before the court today, and has expressed your what? Your?
Sorry, sir.
And expresses misgivings. He prays that on the condition that apology be accepted. Stop. Next para. Though the matter is serious, inasmuch as a litigant has chosen to speak to the press and also cast aspersions with regard to proceedings thereof as reported in the media. As the writ petitioner has expressed unconditional apology and further added that the same was due. It's not a picture. Shalla's comments on mining lease under HC scanner. See? It's ignorance. This court accepts the same. Whatever is directed to file affidavit signing unconditional apology by tomorrow. Yes. Just a matter after 2 weeks. Yes. By tomorrow you file it.
28?
It's personal. Yes. He is one and his personal appearance is dispensed with. Don't do it in future.
28?
In fact, my lord has heard this matter before. Short matters, very short matters. Two are identical cases. I don't know, my lord. Subject to lordship convenience. So far I am concerned, I am ready. But subject to your lordship convenience.
So it was majorly heard on the last occasion regarding the not holding of DPC and whether DPC should be as per the old rules or the new rules.
We'll hear it again. Forgotten everything. Overburden also is.
I understand.
Too much. Going talking to the press is the thing. Yes.
When you know.
Anything else? Yes, this is a matter after 1 week. We'll take it up.
Obliged.
You said that's already been heard.
Already heard.
Let me see my note is there or not.
This was in Nehu, certain people were supposed to be appointed. They had a DPC called and it was
rules,
not held.
DPC, and some. Is this embargo?
Yes, because they are saying that an UGC had written a letter to them not to
conduct the thing.
Yes.
People pending finalization of common cadre rules. So we did not hold the DPC.
That means you have no case.
No, thereafter I filed a rejoinder and additional affidavit.
Okay, we'll hear you. Yes.
All right.